Good morning, everybody. How are you? My name is Debbie. Welcome to my channel. We are on day 11 of the Karen Reed retrial. How is everyone doing? I am sorry about not doing full spectre this morning. I had a horrible evening yesterday. So I wanted to sleep in today. Judy, drop in knowledge. Common players between Reed and Birchmore investigations. Officer Seraph, Officer Lank, Trooper Fanning, Detective Kevin Albert, Trooper Garino. Also occurred in Canton, Norfolk County DA's office, and the FBI investigation. Sandra Birchmore was a young lady that was involved. Judy can correct me if I'm wrong because I'm not really up on this case, but a young lady that was involved in like some kind of program for young people that wanted to go into law enforcement, like a summer camp thing for kids. I think she was like 14 when she started going to it, and they kind of groomed her, and she was involved with, I think, more than one cop as a child. And then Junior ROTC. Thank you, Judy. And as she grew up, they stayed involved, and she got pregnant by a cop that was married and had kids of his own with his wife. And she was found unalived, and it looked like she did it herself, but was then found. I don't know. Did they ever prove that it was him that did it? See, I don't remember. I'm not up on this case. I just know, like, the basic, like the illusion that it was not what it appeared to be. That's basically what I just said is like all I know about it. But my understanding is that was part of the FBI investigation as well as the Brian Walsh case where he supposedly killed his wife. Now this one I don't know far well. Okay, he was arrested a few months back. Okay. Now the Brian Walsh case, supposedly he unalived his wife and they never found her body. I don't know if he did it or not. Like, I know nothing about that case. We watched bits and pieces because I couldn't find the whole hearing. We found bits and pieces. It was like a court TV, like one of their news things where they show bits and pieces of a hearing, and then they have talking heads talking back and forth about whatever. And I showed you guys that on the Brian Walsh case, which I know nothing about. And we're going to do his trial if it's streamed whenever it happens. I don't even know what the dates are on that one. But some of the officers from those two cases were also involved in that case. So, and that's all I know about that. So, in one of the Karen Reed hearings, Eliza Little stood up and made a motion to get those records as well. Because they wanted to bring it up in the Karen Reed case to prove, I guess, collusion, incompetence, corruption. I'm not quite sure how they were going to use the records. But there was a motion from the Commonwealth to exclude that. When was that, Tootie? Yesterday? I know you sent it to me. Well, it's probably gonna take me too long to find it. Anyway, um, but Hank Brennan did a motion to exclude any mention of the Sandra Birchmore case, and that motion was allowed unless the door is opened. So unless Hank Brennan brings it up accidentally somehow, or if he says something that gets the witness to somehow mention Sandra Birchmore, I guess, then the defense can bring it up. I guess. I don't know. I don't know how they were going to use that. I can't imagine. Oh, the council wants to see Beth, but it's in sidebar, so we don't get to see it. Come on, StreamYard, do good. You did good yesterday. Do good today. Alrighty, come on. All this police corruption just makes me sad. Oh, yeah, that makes sense. It shows that they cover up crimes of other cops. Okay, yeah. Defense. Okay, so yeah. I don't know how they would slip that in though. I mean, I guess they would just have to flat out start asking questions of like if they got one of the troopers on the stand that worked that case, they would just have to start asking questions about the Sandra Birchmore case. Like, how would they get that in? And then that would totally confuse the jury. I don't know. There's Peggy. Paul's on the back row again. Wonder what they're talking about. Hey, just because. Hey, Carla, did I say hi to you? I'm sorry. I still have a little bit of a headache. Man, last night was awful. Headache got worse. I was nauseous. Oh, because he's our best detective. Yeah. That could have worked. They could have brought that up. But I still say they should have asked about the badge and the gun thing. He almost went there. I thought he was going there. I got all excited. I thought he was going there, and then he didn't. I was like, what? You had an opening right there, AJ. Why'd you pull back? What's happening? Yeah, I didn't eat dinner last night because I was like, I'm nauseous, but I don't know if I'm nauseous or hungry. So I was like, we don't even have crackers or anything because I'm like on a low carb diet, right? So like I don't even have crackers I can nibble on. So Travis, bless his heart, he's so good to me. He went out and he got crackers and ginger ale, and so of course the dogs became my best friend because I had crackers. I'm like, and Travis like, get up in the bed with mommy, she's sick. I'm like, well, yeah, they're definitely gonna get in the bed with me now because I have crackers. I've not been that sick in I don't know how long. I was like, how did I do this? Like once or twice a week for years before I got that area. I wasn't a migraine. It was like my head just felt like it was going to explode. I don't know what. I have no idea. Yeah, they could have, since Garino was on the other case, they could have opened it up with that. They could have asked Garino, but they didn't even cross Garino, did they? See, my headache was so bad by the end of the day yesterday. Like, I didn't even know what was going on. I was just like, please be done. Please be done. And then she ended up like, thank God. Hey, Robbie. Oh, it could be pollen. I didn't think about that. I don't know, but I don't know if it's coming from my neck. Like, I don't know. Look. I don't know, but oh, it was bad. I've not had a headache like that in years. Like I said, though, it wasn't a migraine. It was everywhere. Like my whole head was just. It was almost like I can't even describe. It was not. Hey Terry, it wasn't a migraine. It was just Siri. I did not say your name. Why are you? You should have heard me and Travis having a discussion about Alexa this morning without saying her name. We were talking about my Alexa is not. We switched internets, and I didn't ever hook her up to the new internet. And for the longest time, she did nothing. Like she was just a clock. And now she started talking again. Like the alarm has started going off. She started to give me the weather every morning, but she's still like not connected because when I talk to her, she doesn't do anything. So I'm like, I don't understand. Is she connected or isn't she connected? Is she spying on us? What is happening?
All right, can we bring the jurors in, Tony, please?
But I still didn't say her name, just in case.
You are unmuted.
One time, Recovery Addict said something about some popcorn machine game or something, and it set off everybody, not everybody's, but a lot of people's Alexa in the chat. And everybody in the chat was like, what's happening? Now my Alexa's popping popcorn. What is going on? It was so funny. And it's supposed to be English. You have to like set it to answer to your voice. But it'll answer to any but mine does. And obviously, Scott said it in the chat, but if people had their Alexa in the room where they were watching him, it set off theirs too. So it's not boy specific. I've never set it up to recognize Travis's voice, and in the winter he asks her every day what the weather is, because we have to leave the water running so our pipes don't freeze if it's below freezing. And every night, every evening, he asks her, what's the weather, what's the low temperature tonight, and she recognizes his voice just fine, and I've never set it up. So I was watching a 48 Hours episode the other day where they actually subpoenaed records from Amazon to get, they were trying to find out, they were solving a murder and trying to get records from from Amazon for the Echo Dot that was in the house to see if they could get any recordings of the guy's voice that they thought was the murderer, to see if he'd been in the house. Oh, they should have done that in this case. I wonder if they had an Alexa. And then they could have. No, they weren't. Oh, they wouldn't know if they had. Oh, that's what it's for. Oh, okay. I mean, she never says Travis's name, so okay, I got it. That makes sense. Yeah, because Travis can say, "Stop alarm, Alexa, stop alarm," and it'll. But like now, when the alarm goes off, he'll say, "Stop alarm," and it won't. It won't stop the alarm because she's not connected to the internet. Yet it said this morning it was like package delivered yesterday, and I'm like, yeah, we got it. Yeah, we keep ours. Like I go through spells where I like to have it hooked up, and then I'm like, nope, I'm unplugging her. It can't. I've heard some to say things. So some scary stories or scary videos, um, I think are fake because you can program her to say certain things. I programmed her to say, "I Captain," because I changed it from Alexa as a wake up word. I programmed her to "I Captain" because Star Trek. Okay, why is this comment stuck? Yeah, Travis was right. I should have bragged. Maybe I should turn my camera off.
Having anything to do before the Honorable Beverly Cannoni, Justice of the Superior Court, holding in Dedham within and before the County of Norfolk. Draw near, give your presence, and you shall be heard. God save the Commonwealth.
Oh, good morning.
Good morning, jurors. I have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing? Everyone said yes or nodded affirmatively. Did anyone happen to see here? All right, Mr. Brennan, your next witness, please.
Thank you, Your Honor. The Commonwealth calls Connor Keefe.
StreamYard, stop. You were perfect yesterday.
Come on, start following. Now step up, raise your right hand. Thank you.
You raise your hand. You solemnly swear the evidence given to the court and jury in the case now and hearing should be truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Good morning.
Good morning, Your Honor.
All right, Mr. Brennan, whenever you're ready.
Thank you, Your Honor. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury, spell your last name for the record?
Sure, my name is Connor Keefe. The last name is Keefe.
Mr. Keefe, where do you work?
I work for the Massachusetts State Police.
What's your position with the Massachusetts State Police?
I'm assigned to the Norfolk District Attorney's Office.
Are you a trooper?
Yes,
When did you first start beginning working as a Massachusetts State Police trooper?
2017.
Did you go to basic training?
Yes, the academy.
How long was the academy?
Approximately 6 months.
Did you have any further training after the academy?
On the job training?
Yes.
Yes, in various specialties.
What's your role at the Norfolk County District Attorney's Office?
I am assigned to the homicide unit where we investigate homicides, unattended deaths, suicides, stuff like that. And I'm also a digital forensic examiner at the District Attorney's Office.
Did you have a role in investigating this case?
Yes,
Were you a assigned investigator in this case?
I wasn't the main investigator, but I was involved, yes.
Did you deal with any of the digital forensic evidence?
Yes,
Specifically regarding the digital forensic evidence, did you meet anybody to obtain a phone?
yes.
Who did you meet?
I met Jen McCabe and Kerry Roberts.
When you met with them, did you have to obtain anything from them?
I obtained a consent form and their cellular device.
After you received their devices, where did you bring them?
They were brought back to the forensics lab located at the Norfolk District Attorney's Office.
And what, if anything, did you do with either or both phones?
I conducted a forensic extraction on those devices.
An extraction, is that a copying an image of the phone?
Yes,
Is that different than analyzing the phone?
yes,
Were you involved in analyzing Kerry Roberts' phone?
no,
Were you involved in analyzing Jennifer McCabe's phone?
no.
Was your role limited to attaching it to grade key and doing the extraction?
That is correct.
And did you do that?
Yes,
In addition to the phone extractions, If you take us back to January 29, 2022, were you involved in going to 34 Fairview Road in Canton, Massachusetts?
Yes.
Do you know about what time you went?
5:30.
What was your role at 34 Fairview Road that evening?
I was asked by my supervisor, Lieutenant Brian Tully, to assist in processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
How would you become aware if there was a piece of evidence found?
The CERT team would alert
Hey, Jill.
I would secure the piece of evidence in a bag, evidence bag.
Do you know if they're time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please. 74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Do you have gloves?
Yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence. Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir. Sorry.
With the court's permission, can he show the item?
Yes.
Thank you. Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back
That
in the
shoe
bag,
you freaking
I'd
knew.
ask this to be marked as an exhibit.
All right, any objections, Tina?
There's no objection.
Exhibit 77.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location.
Time that you write on the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that could be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please.
No. Doesn't look like it's been laying up the snow. I mean, I don't know. I don't get snow in Florida, so I don't
And
know.
preferably 75A,
I'm
please.
jealous of the panhandle.
Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items? Ms. Gilman, you could take that down, please. Thank you.
I don't think it does.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury.
I was so happy yesterday when you got it. Why are you doing this to me? It shouldn't be this cold. We don't get snow. I could have driven like 2 hours north and seen snow.
Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Ugh.
Is that, is it consistent with the same
I
material?
have a feeling
Yes.
that's not a way to
If you could
store
put
them.
that back in the bag, please. I'd move this into evidence, please.
Because it should break.
Okay.
Yeah, I thought the cocktail glass. I can't talk. The cocktail glass I thought was clear. There is video of him That stupid video from the waterfall, there's a ding dang flag in the way. That was the most ridiculous. I don't know when they put the flag there. I don't know if they put it there afterwards. If they put the flag there after they placed the camera there, that's a stupid place to put the flag. If they put the camera there after the flag, it was a stupid place to put the camera. Either way, it's bad because the flag kept flapping in the wind and covering the camera. But he did. I mean, you got to really look at it hard. But he does have glass in his hand. But you can't really see what kind of glass. Is it clear? Is it like it's really, really, really
So, Mr.
hard?
Brennan, I leave it to you and the witness how you do that part.
Yes.
But as far as the taillight breaking,
It's a small chip piece. You don't know how it became chipped.
I do not.
I'd ask you to remove that chip.
I think it should have been stored differently. It should be
I'd like you to
stored
safely
where it can
secure
get
it, bring with
broken.
you, and bag it when you leave.
Yes, sir.
And I'd like to introduce that exhibit.
What?
78.
So we're going to mark the little chip.
You
Ms.
you'd like to mark
Giannetti
it?
asked to
Okay.
mark that. Yes.
Then we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
78.
Thank you.
Small chip out of the. I'm confused. What is happening?
Exhibit AB for identification.
I know what's
Thank you.
happening. I'm just saying. I don't know why it's happening.
Trooper, we have one more bag of items to go through.
Yes.
Could I have exhibit 73, please?
He's touching things with the gloves on. That's the nurse in me.
Sir, if you could look at exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you a photo. Do you recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Is there an accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as
I
an
feel
exhibit,
like
please.
they did. I want to say they did, but I'm not.
There's no objection, Mr. Giannetti?
There's no objection, no.
Exhibit 79.
With the court's permission, could we show exhibit 79 to the jury?
Yes.
I don't remember. Yeah, I'm fuzzy on that, just like you. I don't.
Gilman, would you be able to close? Thank you.
Yeah, that's what I'm thinking too.
You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
You know what? Just because it might have been.
Are these different in color than the last pieces you showed?
Yes.
When she was on the stand going after.
With the court's permission, could the trooper show these pieces?
Yes.
Saying that. I don't remember. Were these pieces broken before they went in the bag?
Thank you, trooper. I'd move these items into evidence.
No objection, Your Honor.
Right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Mr. Giannetti?
Please, Your Honor, thank you.
Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Kerry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
It allows the trooper or law enforcement to, with the owner's consent, we are able to conduct an extraction of the device.
Okay. And on that consent form, there is a description of the item itself.
Yes.
In this case, it would have been an iPhone 11.
Yes.
And there also is an identifier with regard to a specific phone called the IMEI number.
The International Mobile Equipment Identifier.
Okay. And that would be included on the form as well because it identifies the specific iPhone 11 that Jennifer McCabe had, correct?
Correct.
The password was provided on that consent form,
Yes.
and the form was signed, correct?
Yes.
By both Jennifer McCabe and by you, correct?
Yes.
And there was also a second trooper that would have signed the form as well.
That's correct.
With regard to the timing of the signing of that form, Jennifer McCabe dated it February 2nd of 2022.
Yes.
You also dated it February 2nd of 2022, correct?
Correct.
Jennifer McCabe did not list a time, but you did, correct?
I would have to look at the consent form.
Okay, so your memory, you don't remember what time you indicated or if you indicated a time, but looking at the consent form would refresh your memory?
Yes.
May I approach, Your Honor?
Yes.
Now, I just ask you to read that silently and then look up at me when you're done, Trooper. Having reviewed that form, does that refresh indicated a date and time?
I did, yes.
And what was the date and time that you indicated?
It was February 2nd, 2022, 12:08.
And that would have been 12:08 p.m.?
Correct. 12:08 p.m.
The document that I handed you is not an original, correct?
No, it's not.
Does it appear to be a precise copy of the original, however?
Yes.
May I offer that into evidence, Your Honor, please?
Is there an objection, Mr. Brennan?
No, subject to redaction.
Okay. So don't put it up on the,
I will not.
Exhibit 81.
Now, Trooper Keefe, as of January 29th of 2022, you were colleagues in the same state police unit as Michael Proctor, correct?
I was.
At that time, was the unit called the CPAC unit or was it called Norfolk County Detectives?
I don't recall when it changed.
Okay, it's been called both, correct?
It has.
As of January 29th of 2022, there were only 10 troopers in the unit, including supervisors, correct?
I don't know.
It's a small unit, is it not?
Relatively small.
Within the CPAC or the Norfolk County Detectives, every case that comes in is assigned to one particular trooper as the lead investigator in the case, correct?
That is something that a supervisor would do, not me.
And have you been assigned as the lead investigator in other investigations?
No, not a homicide investigation. No,
You have not yet.
no.
The lead investigator is,
Yes,
Michael Proctor was the lead investigator for the investigation into the death of John O'Keefe, was he not?
yes.
If somebody asked within your unit, while this case was going on. Whose case is it, or who has that case? Your answer would have been Michael Proctor, correct?
Yes,
The two of you have worked cases together in the past, correct?
a few.
You've worked on this case with Michael Proctor, correct?
Yes,
And in fact, within your work on this case, you actually partnered with him for certain assignments within the case, did you not? On October 21 of 2022, you and Michael Proctor interviewed Sarah Levinson together, correct?
no, I don't recall that.
If I may just have a moment, Your Honor.
Okay.
Okay, Cooper, you do not remember interviewing Sarah Levinson on October 21 of 2022 at 12:20 p.m. at the Norfolk DA's office. Is that your current testimony?
Yes,
If you saw,
to an extent.
may I approach you, Honor?
Yes.
No, not at all.
Yes.
Yeah.
I didn't do anything that time. I didn't hit a button. I didn't do nothing. StreamYard. Chill. Making up for being. faster, dude.
Going to ask you any questions about the specifics of what Sarah Levinson said, so you,
I'd
you
just
don't
like
have to
to-
brush up on that.
I'd just like to refresh. Take a
Sure,
look, sir.
go ahead.
Oh. Okay. That's comforting that it's not just me. Oh, but he doesn't use StreamYard. So this is the interview with Levinson, Sarah Levinson, that he's reviewing.
Having reviewed that report, does that refresh your memory as to whether or not you participated in an interview of Sarah Levinson with Michael Proctor on October 21st of 2022?
Yes, I don't recall the specifics, but
So when you say yes, is it your current testimony that your memory is refreshed that you were actually there?
yes,
And the two of you would have participated in that interview together, correct?
yes,
But you did not write the report, correct?
no, I did not.
Michael Proctor wrote the report, correct?
Yes, he did.
He was the lead investigator writing the report, correct?
Yes, he wrote this report.
He chose the language to use in that report, correct?
I did not have any input on how he wrote this report.
Right. You had no input. You weren't standing over him while he was typing it, correct?
Correct.
Now, other examples of, and actually, let me take that back from you if you don't mind. Let me approach Judge.
Yes.
Chill, dude, you're not responsible for him. Good Lord. He screwed up. It's not your fault.
Other examples are the reports on the videos that you, well, strike that. Let me start by saying this. You, or asking you this, you retrieved videos from both the Waterfall Bar and Grill and C.F. McCarthy's, did you not?
That's correct.
You and Sergeant Buchanan retrieved the videos from C.F. McCarthy's, correct?
Yes,
But lead detective or lead investigator Michael Proctor was the one to analyze the video and write a report on it, correct?
I would have to see that report, sir.
Sure. If I may approach?
Okay.
Oh, I'm sorry. And again, if you read that silently to yourself and look up at me when you're done. Okay, having reviewed that report, does that refresh your memory about Michael Proctor being the one to write the report on the analysis of the waterfall video?
Sir, I only obtained a copy of the surveillance video. I
Right.
did not do any analysis on the video.
That's my question. It was Michael Proctor who did the analysis, correct?
Yes,
And that, by the way, I said Waterfall. Is that CF McCarthy's there, or is that Waterfall?
this is CF McCarthy's.
Okay, I meant CF McCarthy's. He was the one to review that video, correct?
Yes, again, I only got a copy of the surveillance video.
Sure.
I did not do any
And
analysis.
with regard to the Waterfall Bar and Grill, that was another circumstance where you and Sergeant Buchanan were the ones to retrieve the video, correct?
Yes,
But again, lead investigator Michael Proctor was the one to analyze the video and write the report on it, correct?
yes, I would have to see that report as well, sir.
Now, another member of your unit was Trooper David DeChico, correct?
Yes,
Within your unit, did Trooper DeChico have a nickname for a first name?
Objection.
May we approach?
Oh, what is his nickname? I don't remember anything about him having a nickname. You can have the nickname. But dang it, StreamYard. Oh, I forgot about the cookie. There's a bakery in Massachusetts that makes a cookie that has a picture of that fan on it. I want one. Oh, he's smiling. He's doing it.
Trooper, in terms of the troopers that were in your unit as of January 29th of 2022, which members of the unit had the least amount of time in the unit at that time?
I don't recall.
Were you one of the newer members of the unit?
As of January of 2022?
Yes.
Yes,
Trooper Michael Proctor had more experience than you did as of January 29th of 2022, correct?
he could have. He'd been on the job longer.
Okay, well, if he had been on the job longer, then certainly that means that he did have more experience, correct?
Now, that's God.
It depends.
You attended the autopsy of John O'Keefe on January 31st of
I did.
2022. And with regard to other members of your unit, you were the only one to attend that autopsy?
Yes,
That was done at the medical examiner's office
the medical examiner's office in Sandwich, Massachusetts.
in Sandwich, Mass. And it was Dr. Irene Scorti-Bello who performed the autopsy, correct?
Yes,
Had you met her prior to that day?
no,
Had you spoken to her prior to that day?
no,
Did you know before the autopsy was performed that your former colleague, lead investigator Michael Proctor, had discussed the case with Dr. Scorti-Bello without telling us what you knew of what was said?
Objection.
With regard to Dr. Scorti-Bello's knowledge of what the state police theory was of what happened, did you have to explain that, or was it your understanding she already knew what your theory was?
Objection.
This is Dave. You can ask that differently.
What, if any, conversations did you have with Dr. Scorti-Bello about what your unit's theory was about what happened to John O'Keefe?
there was no theory.
Okay. You did not provide any theory to her, correct?
I did not provide a theory.
You learned at the autopsy from your observations that John O'Keefe had 2 black eyes and a swollen right eye, correct?
Yes,
You also learned that there was a small cut above his right eye, correct?
yes,
And there was a small abrasion on the left side of his nose, correct?
I would have to reference the report for the exact words.
Okay. If I may have a moment. May I approach, Your Honor?
Look at that chin jet.
You want this one back?
Oh, please, thank you. So I placed another document in front of you. Just take a look, read it silently to yourself, and look up at me when you're done. And I would direct your attention to the second page for the question I just asked you. Having reviewed that report, Trooper, is your memory refreshed as to whether you observed a small abrasion on the left side of John O'Keefe's nose?
Yes.
Now, was this the first autopsy that you had attended, or had you attended ones in the past?
I cannot recall.
It could have been the first one?
Most likely not.
When you're attending an autopsy as a member of the CPAC unit or the Norfolk Detectives Unit, you are expecting that the medical examiner is going to examine the body, correct?
Yes.
And you're there to witness that examination, correct?
Yes.
At the end of the examination, you are expecting that there will be a determination as to cause and manner of death, correct?
Not.
In this case, when the autopsy ended, you left the medical examiner's office, correct?
Yes.
When you left, your understanding was that the cause and manner of death was still undetermined, correct?
Objection.
Sustained.
You knew when you left that Dr. Scorti-Bello had seen the scratches or bites or injuries to John O'Keefe's arms, correct?
Objection.
Sustained.
You knew when you left that in your presence, Dr. Scorti-Bello had seen the injuries to John O'Keefe's arm.
Object to the line of question.
Sustained.
May we approach?
Okay. Jurors, feel free to stand up.
Oh, geez. Brennan, I hate you so much. I have never hated a lawyer as much as I shouldn't use the word hate because I don't. I dislike his tactics, but he is a good lawyer. Like, if I lived there and needed a defense lawyer, like really, really bad, because he is a defense lawyer, he's just a special prosecutor for this case. And even like Peter Trago said the same thing. He will probably get more business as a defense lawyer after this trial because of this. Like, he gets the job done. He might not go about it. Afterward, like, ethically, honestly, whatever, but he gets the job done.
Were you watching Dr. Scordy Bello as she was conducting the
Probably
autopsy?
just like,
Yes.
that's good.
Did
Yes.
she appear to be looking at John O'Keefe's body?
It's the same thing, just
Uh,
ask them to come.
What direction was examining John O'Keefe's body?
I don't recall. She was doing her job conducting the autopsy. She was
And in
looking
order to do
at the
that,
body.
I'm sorry?
She was looking at the body, I
Okay.
assume.
Thank
I'm not
you.
in.
Thank you. And looking at the body, you saw her looking at the body, correct?
Yes.
And looking at the body included an arm, correct?
Yes.
And it was at the arm was not covered up during the autopsy, correct?
No.
It was open for you to see, correct?
Yes. Yes.
You didn't notice any obvious broken bones, did you?
I'm not a medical expert.
That's the one.
And it is common practice for the state police to attend autopsies when there's an undetermined death, correct?
Yes.
It is not at all common for the defense to attend an autopsy, correct?
I've never experienced that.
Right. And there was no defense attorney or defense expert at the autopsy of John O'Keefe, correct?
Not when I was there.
You were there, correct?
Yes.
Input, correct?
We don't give input. We give the facts that we know so far in the case.
Okay. Well, giving the facts is giving input, is it not?
It's not input.
Oh, baloney.
Okay. Did you talk to Dr. Scordy Bello during the autopsy?
Yes. Yes.
And at the end of it, you left without her ruling it a homicide, correct?
Objection.
I have nothing further.
No, none, thank you.
All right, you're all set, Trooper.
I swear, StreamYard reads my moods. As soon as I'm like super into something that's going on, it crashes.
All right, we're going to take a break more.
It's a little bit more break than we normally take. Take your coffee. We'll take a half hour.
What the fudge is going on? None of those questions Well, I don't know legally because I'm not a lawyer, but I don't think any of those questions were inappropriate.
Decision from Maryland, just cursory while we were waiting for the witness. And that was the March decision. And I can't stress enough that this, see, I'll hear the Commonwealth's response, then I'll go finish reading everything else she gave me. So what are your concerns about Dr. Hyde or what? But I remember she testified the last trial, so you have transcripts.
Understood, Your Honor. I first want to just get the evidentiary basis. This is straightforward judicial notice. There are two separate decisions which require and that's a shall.
It's an SJC case, so yes.
Yes, okay. So now to the Maryland case. So that's governed by federal, Massachusetts Rule 39A, and that is records of courts of state or the United States proceedings. And of course, a court is judicial proceedings of a court of another state or of the United States shall be competent evidence in this Commonwealth if authorized by the attestation of the clerk or other officer who has charge of the records of such court under its seal. So I have with me, Your Honor, that State v. Herrera, Maryland case. I have the certified copy with me from the clerk.
All right, so we can mark that for identification.
Thank you, Your Honor. May I approach?
Yes.
He's halfway there before he asks. Stringer, today is not the day. I still don't feel well. Don't do this. Trial is good today. I don't need your chiz.
Assuming Your Honor determines that the seal is the seal in evidence, to the extent the Commonwealth seeks to argue relevancy or materiality, that argument is precluded, Your Honor, in the best evidence of that conclusion is the immediate section below in Rule 39, which is notice of the law of the United States thereof, or country, whenever it shall be material. So the rule knew how to put in a qualification or condition when they introduced materiality in B, but they didn't do it in A.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony. What I want is to have admitted evidence, have it and question her on what she presented to the Bible. And that is what.
In one area, right? One specific area.
Well, you can.
Decision.
Just what's in the decision, there's two parts of that decision in two areas. In that application history.
Right.
But the court also got the Apple source code.
Nobody in the country has the Apple source codes, right?
Point exactly, Your Honor.
Does anybody remember who that was?
Exactly what you're asking
If I could
me
proceed
to allow.
give you the answer, Your Honor, I
Go
will
ahead.
explain it. It's a very short answer.
Okay.
What I want to do is with regard to her 227 times anticipated testimony, where she, in conclusion about that timestamp, she is not using Apple source code to find out where that's located specifically in the phone and what it means. She is using a surrogate to do, using this decision to say in Maryland, you try to do the same thing with regard to FLH. You try to use a surrogate approach and make an opinion about whether that is in fact what's in the phone. She can't do it, and that means her testimony on 227 is not reliable. I'm not looking to exclude it. I'm looking to cross her on her reliability for the conclusions I anticipate she's going to make on 227.
So if she is not asked about that, then what?
Oh, if she's not asked about the 227, and I want to think about it, but I'm 99% certain I am not going to pursue that at all.
Okay, what do you say, Mr. Brennan?
This is an attempt to try to malign a witness with something that's wholly unrelated, not relevant to opinion. It is not a law that is admissible. It's an opinion. It wasn't even about in a Daubert hearing, the court did not allow testimony on significant location. That's not the case here. Try to conflate the argument saying it has something to do with Apple 227. There is absolutely no basis for that argument. They want to say that another court rejected something about you, therefore the jury should reject you. There is no relationship between what she is going to testify as a basis and that opinion. That opinion did not say she was wrong. It said that it was not admissible under Daubert, unrelated. Nobody has the Apple source code. No expert can testify about Apple source code. It's only owned by Apple. And so using the words like surrogate is a way to try to cheapen her testimony in front of the jury. This here, number one, what he said, I really can't follow him. I don't understand, other than he's trying to draw some type of relevance and materiality. There's none. There's none. This is not a denouncement. She hasn't been found incredible. There's nothing about her methodology that has been rejected by a court. This is on significant location. And although she looked at it, that's not part of this opinion whatsoever. And so because another court didn't allow something under a Daubert, has nothing to do with this case. Nothing.
And what is it that you expect her to testify to, Mr. Brennan, regarding the 207 scam? We did not have this issue with Mr. Whiffen, right? This was not raised with Mr. Whiffen.
Oh, it was. The 227 timestamp would.
No, that was raised, but this, what was problematic in Maryland? The same thing that was problematic in Arrington.
That's correct, Your Honor. It wasn't raised because Mr. Whiffen has not been Daubertized with regard to Apple source codes. And if I could, Your Honor.
Okay.
Mr. Brennan has made a relevance argument. He keeps anticipating my cross, which he has incorrect, by saying it's not relevant. That doesn't go to the admissibility in my cross. I'm entitled to cross her on her reliability. And if I could, Your Honor, in the State Herrera decision, if Your Honor would look at page 3, please, at the bottom, the paragraph, it says, in assessing the reliability of an expert's methodology, I get to do that on cross. It's not limited to a Daubert hearing. Every expert can be crossed on their reliability of their methodology. And lastly, with regard to the Apple source code, if Your Honor would please turn to page 6, the last paragraph, it says the issue raised in this case stems from the fact that Apple's algorithms are proprietary and the expert did not have access. That's exactly the situation here and what I want to cross her on. So in conclusion, Your Honor, the fact that how she tried to get around the Apple source code for methodology in the Herrera case, she got Daubertized on because it was liable. That's exactly what I want to cross her on, is her reliability, how she's trying to get around them. In this case, it's just basic cross-examination.
You can see the plan to dehumanize somebody, Daubertized, to use a term to suggest some type of conclusion that has no basis in fact, is an attempt to just dehumanize her and limit her testimony and credibility without any basis in fact. In that case, it did not deal with the search of a tab and a suspended state in Safari. It didn't deal with the timestamp. It was an entirely different issue. By their analysis, if an expert goes into court on a motion on anything to do with data forensics, and the court says that issue is not admissible, they should be impeached when they go and talk about a totally different issue in forensic data analysis at another case. They have not shown any evidence that this issue has anything to do with her effort in the timestamp. They just used the word methodology. Her methodology was questioned in an opinion in a different court. Has nothing to do with her opinions here. What information do they have that her methodology in this analysis has been rejected by any court? What evidence do they have that the methodology used in this case is unreliable or improper? They don't have any. In fact, they called an expert themselves in the last case who tried to provide what he believed to be methodology, and they presented that. They proffered that evidence as reliable. No different on this subject. Herrera case is a totally different subject.
Your Honor, first of all, as the court has noted, the first trial is the first trial. This is this trial. I wasn't at the first trial. The most important and probative aspect, Your Honor, is I don't want to have to give away my entire cross in this argument.
No one's asking you to. I'm not asking you to.
There is part of Ms. Hyde's slide that go to location. There's a part from the 227, but the good part of her slide presentation that she's going to present is on location. It is with regard to health data steps. So there are certainly aspects directly relevant. Here is the issue with the 227 in addition. There is, for her methodology, she's claiming a certain conclusion and opinion about the 227. There is no period, there is no article that she can cite to support her methodology to come to the conclusion that the 227 timestamp, one, doesn't exist anymore, or two, doesn't mean that the search occurred at 227. That's what she's opined on in her reports pre-trial, and that's what I anticipate she's going to opine on when she takes the stand. I'm entitled to cross her on that. We can't be saddled. It's irrelevant what our witnesses said in another proceeding. It's what this witness is going to talk about in this matter, and I'm entitled, and my client's entitled, to have me confront this witness on what she's going to testify and her methodology. So my point is, Your Honor, this decision to impeach an expert, the fundamental issue, and I don't mean to dehumanize her, I would use the term Daubertize. She's deemed unreliable. Attorneys who do experts all the time, that's the verb you use to shortcut it, but I won't use it. I have no intention to dehumanize her. What I intend to do is to impeach her on her reliability. So in conclusion, Your Honor, the Herrera case, she was deemed not reliable. Competency. And the Commonwealth believes the case is not relevant. If Ms. Hyde believes it's not relevant, let Ms. Hyde defend that on the stand. Let Ms. Hyde make that point on redirect. But I can't have my client's constitutional right subject matter she's going to testify on by anticipating what I'm going to provide for cross. I've given it, and I respectfully submit, Your Honor, this is basic cross of an expert witness, particularly when their methodology on data forensics has been deemed not reliable by a court. And one part is the location.
Do you intend to introduce that, Mr. Brennan?
It's not significant locations. There are locations in the database that develop the opinion that the timestamp 227 is not related to the search. She has not been deemed unreliable. It is the issue of the significant opinion from a court that she's an unreliable expert. And this is how they're going to distort it. Invoking the Constitution, invoking the client's rights has nothing to do with the analysis. That is a totally separate subject, or an opinion simply wasn't let in a different court out of this jurisdiction. It wasn't this opinion, it wasn't this methodology for the opinions that she's going to offer in this case. And so if you look at the case, it's a totally different related item. It's as if a reconstruction expert went into a court and attempted to give an opinion about a medical diagnosis, and the court wouldn't allow that medical diagnosis in. In another court, in another jurisdiction, they would not be able to be cross-examined that in some court, there was an opinion they offered that was deemed inadmissible, unless they were talking about the very same methodology and the very same point. This has nothing to do with her opinion whatsoever. It's just an attempt to try to endorse the defense's attempt to not credible. The fact that it's two different methodologies is two different.
Well, word, go ahead.
Thank you. Credibility. This is a credibility issue. This is a reliability. This is the essence of what experts do. You have to show that your methodology is reliable. It's a red herring to bring up credibility. The court opinion.
And this is the equivalent of a superior court opinion, right? It's not an appellate decision.
It is the equivalent. I respectfully don't think the level of the court is at all relevant. Unless you get it overturned on appeal, then this would be a different matter. But this is the valid case. It shall be here. In the Commonwealth, the question first for the court is this admissible? Can it come into evidence? To me, that's a non-issue. Rule 39 says ipso facto, yes, as long as I've got my copy. So it is in evidence. I don't know why we're perseverating respectfully on whether I can question her on something that's going to be in evidence about her. Final point, Mr. Brennan incorrectly said it wasn't about her. The final sentence, the decree section on page 7 says, accordingly, defendant's motion to exclude expert testimony regarding the significant location data obtained from the forensic cell extraction is granted. She's the only expert name that's mentioned throughout this. And I'll conclude my point, Your Honor, where I start, and that is besides knowledge. In regard to her PowerPoint, you heard Mr. Brennan's answer. He is going to include, he has included in her PowerPoint locations, steps, etc. It's exactly what the issue here, the 227 timestamp. She has no, and this will be developed for, she has no peer review to say that how she is determining that 227 timestamp not be in the data. She has nothing to support that. Nothing in this case with the data forensics. Point is, if the Commonwealth believes that this is irrelevant to what Ms. Hyde did, let them come back on redirect on that. I shouldn't anticipatory have cross-examination struck and get to pursue that with the witness. It will become eminently clear that it's a proper basis for cross-examination.
All right, and Mr. Lessie, have you thought about if the Commonwealth does not get into the 227 timestamp, whether you think you're still entitled to do this?
Your answer, are on my answer, I would be entitled, I would say that into 227, I won't go after it. I won't pursue it. I won't pursue use of this.
Then why call her?
We necessarily would have to on some basis, because in order for the witness to explain to the jury her opinion that Ms. McCabe did not delete any Safari browser searches, she would have to identify the search, where it is in the databases, and how she can tell, how she knows that it wasn't deleted by a user. The same with the second part of the phone calls. But if I could avoid talking about 227, I would, but it is necessary for the basis of her opinion. There's just no way around it. And again, this is something that after a defendant expert may or may not testify, could be addressed at that point. There is no burden on the defendant. I'm not being presumptuous, although there was a offer of proof earlier on similar evidence. But not knowing the court's wisdom on whether I'll be entitled to rebuttal, I do not want to lose the opportunity to address points that were made in the opening that have absolutely no basis in fact and have not been proven in any way to this point in the case.
So I asked earlier whether the defense intended to call Mr. Green, and you believe that you do, right?
Your Honor, we not make we're going to hold, but if I have 10 seconds. Mr. Brennan can't have it both ways. He can't say, yes, I need to address the 227 timestamp, and then deny me the ability to cross-examine fully on this expert's methodology and to impeach her and to get at her reliability and her competence, which is a key issue of crossing an expert. Her competence has been determined in this decision. And it is her, because it was her report that was the basis for the court to not allow her to testify. They can't have it both ways. You can't say, I need to do it in direct, but no, I want to handcuff the defense on cross-examination. Now to answer your question, Your Honor, we are going to have a witness that is going to address the 227 issue. Whether it's Mr. Green or somebody else, we haven't determined. My point on that, Your Honor, is we shouldn't be limited in our cross-examination of the Commonwealth.
No, I'm just thinking it in terms of whether this might be appropriate for rebuttal. That's.
Yeah. And Your Honor, my point would be that's obviously can't have.
Yard, knock it off. Okay, any day now. Thank you.
They shouldn't get rewarded with sort of having a free. Call a witness. That should dilute my ability to cross-examine this witness on an issue they're raising. I'm not raising it.
You can see why I wish I had. So I will do what I can in the next. See, she's here.
Your Honor, may I ask? May I, Mr. President?
I just want to know, is she here?
Yes, Your Honor.
Can she stay another day if need be?
I think she'll do what the court directs her to do, not be here. Well, may I approach?
Is she the one? You guys remember the one day I accidentally filmed the jury and he freaked out and then said no more filming, and then she ended up being on Zoom? Is that the one? Was that Hyde? I think I remember her. I think that was the day that and then it came back on a Zoom feed. I think it's time to email StreamYard again and say, look, it is not my internet. Why do you keep telling me it's my internet? Because it's not. I want you guys to look out for any nonverbal communication between the judge and Hank Brennan. Because there is a clip. I'm sorry for the rattling. If you guys can hear it, I'm eating crackers because I still don't great. There is a clip from the voir dire hearing with Wolf, where and he cheated, and then she's got her glasses off. He looks at her and shakes his head no. He's standing by Wolf. He's standing by the witness. He looks at her and shakes his head no. She puts her glasses back on and then she writes something. I don't think it looks like she's looking at him. But some people think that she was with them. So we're gonna be real profilers. We're gonna be investigators. We're gonna watch for nonverbal communication between the judge and the Commonwealth. Just out of curiosity, because I want to. So is she there, like, to be the next witness? And they're just now bringing this up? Yeah, that's not good. And as much as I don't like her, I agree they should have given her better notice on this one if she's there waiting to testify. That might have been a good idea. If it's the one, I think I know who she is. And she, I don't know, she really like loved her job and loved explaining it. Like she was enthusiastic about it. Doesn't mean she's right though. At the time, I didn't follow anything that she said. Just like I didn't follow anything Whiffen said. Still didn't. I mean, I get the explanation that if you go back to a tab that's already been open, that it will clock it at that time. I understand that concept. Like, I'm not stupid. That all, but to me, it doesn't make it the only Google search that was deleted, and then searched for again, and searched again twice with one really badly misspelled and one misspelled exactly like the one that was deleted. That just seems research it. And if that's true about the tab thing, she must have, well, if it's true about the tab thing, then she knew to open a new tab at 6 something whenever she made the new Google search. I don't know. The last trial, they seemed to, I thought they seemed to spend almost too much time on that to the point that, almost to the point that it didn't even matter anymore. It was like you're spending too much time on that and not enough time on the other things that are more important about the case. Like, I get it's important than that. The fact that she deleted the Google search and then lied about it isn't the thing that's going to make or break the case. So don't like spend an inordinate amount of time on it. Man, that last cross though, that was so funny. Oh my gosh, that was funny. Was she looking at the ceiling? Watch EDB's react. That's what I do now since I've started streaming trials. When there's something like that, see other people's reactions, I go back and find that in their stream just to see their reaction. I'd also watch Aussie Insider because she does compilation videos of certain things and the different lawyers' reactions to it. I don't know, man. That must take hours and hours to catch the good parts like that and then to put them all together. I cannot imagine doing that. But she does a really, really good job with it. You guys should go check out her channel. It's Aussie, like Australian, AUSSIE, Aussie. Aussie. Insider. Which one is Judge Carroll? Was that Murdaugh? The big decisions? Oh, yeah, that's the one I didn't watch. I kind of feel like I should go back and watch it because everybody, when they make references to it, I have no idea what. I watched um Runkle's recap of the opening statements, and that was all I could handle. I almost went to work at that hospital. Judge Unicorn, he was that good. Yeah, I pediatric nurse. I couldn't watch it. It just, even just the thought of that case is just appalling to me. Just totally appalling. To think that the nurses, I mean, I, I guess if like Child Protective Services tells you to do something, you have no choice, but still, I just couldn't watch it. I just couldn't do it. That used to be an excellent pediatric hospital before John Hop John Hop John, I can't say it. John Hopkins, which I always thought that was like the best of the best, right? But apparently not. When it was just all children's, like my cousin had leukemia, and she lived in, where did she live? Homestead, like almost to Miami, and they sent her all the way up there for her treatments and stuff, and they were great. Or it could just have been that one case that went sideways, but that's bizarre. That case. Oh my God. But Travis, when we met, he lived in Polk County, which is very close. It would have been like not even an hour's drive, probably. And that was one of the hospitals that, had I moved down there instead of him moving up here, that is island of here. had I moved down there with Travis, I would have applied to work at that hospital because it was close enough that I could have, it wouldn't have been because I probably would have worked 12-hour shifts, so it would have been 3 days a week. That wouldn't have been a bad drive for just a 3-day a week, So I would have definitely applied there because I remember them being a good hospital from when my cousin got her cancer treatments there. And like I said, it could have just been that one case. I mean, that does happen where just one case, one case in a hospital goes sideways, and then it ruins the reputation of the hospital. Bev has been making, for the major decisions, I think Bev has been okay. And I think that's only because she doesn't want to get overturned on appeal. But the little decisions, I know. And the thing about not saying the grounds for the objections, that's her own little loophole, because that way she can rule however she wants, because like the objection depends. Like if you say objection hearsay and it's not hearsay, then you don't win the objection, but it could be objectionable on another ground. So she can say sustained or I'll allow it for whatever ground she wants to, because she doesn't let them state a ground. Or grounds if you're Brooks. If I had, if she is impartial and we're just imagining a bias, and I had been her, I would have recused myself for that reason and that reason only, so that I didn't even slightly appear to be biased. Because let's say you are a judge and you aren't biased, but people find out you have some kind of relation to the case, they're going to assume you're biased, whether you really are or not. So you should recuse yourself. And she refused to do it. I mean, does that make sense? I don't even know if I'm making sense right now. I sure as heck feel better than I did last night, though. I don't eat all my crackers now. You're making a mess, dude. I love how Court TV always puts Court is on a short break. Nope, not short. Never short. I actually thought about staying in bed today and streaming from the laptop, but I was afraid I'd fall asleep. You'll see StreamYard crashes, I'm asleep, and you guys are going, oh, what the heck happened? Actually, I've never tried to stream from the laptop. I wonder if that would be better. Oh, that laptop is slow as molasses. Last week when Biggin, was it last week when Biggin had his computer died and he had to go out and get a new one? Someone in the chat said that I think it was 2 years. Computers are only meant to last for 2 years, or laptops are only meant to last for 2 years. And I was like, well, that sounds about right, because I don't think I've ever had a laptop that's lasted longer than that. Wait, Spike, that landed in my shoe. Well, it's stuck in there. Yeah, you're hearing Spike squeaks. He wants my crackers. Spike will eat anything. Belle's a little pickier. I gave her one cracker and she left. It's like, oh, it's just a cracker. Spike will eat anything. If it's edible, he'll eat it. And sometimes when it's not edible, he'll still eat it. Dude. Yesterday, I tried to get him to let me pick him up. And I said, you want to get up here and say hi to everybody? And he backed away. And then I didn't even have food. He came up, he was squeaking about something. And I put the microphone down. I said, talk to Aunt Judy. And he backed away again. Like, you little butthead. Quit growling at me. I'll give you a cracker when I want you to have a cracker. He's so cute. It's a good thing you're cute. He growls at Belle all the time. And I don't know why. They used to be like in love. And now he growls at her all the time. I was like, when did you guys get a divorce? She didn't tell me. She's gotten to where if he's on the bed, she acts like she's afraid to get on the bed. I don't think I've ever. Oh yeah, he has tried to bite her. That usually involves food though. Can you stop, please? This is the longest short break ever. I don't think I don't want to go back and rewatch or not rewatch, but watch the Maya trial. But I do sometimes go back and watch trials that I miss because people talk about them so much. I'm like, I gotta go watch this trial so I know what they're talking about. Like I went back and I watched Rittenhouse and Murdaugh because people were always saying stuff about him, and I'm like, I don't know what they're talking about, so I need to go watch them. Because Legal Bites had a lot of merchandise that referenced Rittenhouse, and I didn't understand. Like, they were like inside jokes, that I didn't get. So, and then Legal Bites didn't do Murdoch because she was moving at the time, and I don't know why I didn't just watch it with EDB when it was happening, but I didn't. And then I went back later and watched it with EDB. I mean, not live, but the rewatch I did on EDB's channel. And I was like, oh my God, why didn't I watch this at the time? That was a long trial. And it was like a trial within a trial because they had the hearing in the middle about the financial crimes. I was like, I so should have watched this when it was live. It would have been so much more fun. I could have, participated in chat and everything. Because that whole trial within a trial part, that was so boring. But I have this thing where you can't skip anything. Because if you skip anything, like, no matter how boring, like, the jury can't skip anything. You have to watch everything because you never know when the slightest, like, even if it's the most boring witness, there might be one little thing that comes out in that testimony that you need. So you can't skip anything. Like in the Phil Spector trial, that windbag expert doctor guy that we all hated, I don't know how court TV breaks up their, what do they call them, legendary trials? I don't know how they break it up. I don't know how many days he was on the stand, but it was in 7 parts. And in the very last part, like every day we were like, oh, we're not done with this guy yet. We're not done with this guy yet. How many more times? When is he done? Because this guy was just a windbag that liked to hear his own voice. But the very last day, we were so sick of him. Couldn't wait to be done with him. And Alan Jackson was a prosecutor in that case, and he was cross-examining him, and he asked him a question, and the guy couldn't answer it. And he said, sir, and then he'd say a few words, and then he'd go, sir, and he'd say a few more words, and then he'd go, sir, because he couldn't answer the question. And so then Alan Jackson said, objection, non-responsive, judge. And the judge goes, no, I'm going to let him answer it. And Alan Jackson said, well, okay, if he can. It was so funny. I got such a kick out of that. I was like, see how funny that was? We would have missed that if we skipped this. I got such a kick out of that. But it's funny because that's why I wanted to watch that trial, because Alan Jackson was the prosecutor and he was really young back then. But there's so much that he does now that is exactly the same. Like, I thought I would see like a big difference, like from young Jackson to now Jackson, I do see a maturity, but still like a technique that has been like honed from then to now. But there's so much that's exactly the same. And because that murder was a gunshot, so he talks a lot about physics in that trial. And this man knows his physics. He knows his physics, just like he did with Paul last year when he was talking about this. He asked a physics question in the Phil Spector trial. That was in 2007. He asked that guy a physics question, and the guy said something about, "Oh, I don't know your college physics." And Alan Jackson goes, "Well, high school, actually." I was like, man, this guy knows his physics. I hated physics. I failed it in high school, and I never took it again. Not in college or any other place. I was like, nope, I don't need physics to be a nurse. I ain't doing it. Too much math. I was like, why is there math in science? And then I went to nursing school, and I had to pass a math test. We had to take it every semester, and like the first semester, you could get so much of it wrong and still pass. The next semester, you had to get less wrong before you could pass. And by the last semester of nursing school, you had to get every question right in order to pass. Because there's a lot of math in medication calculation. But then when you are actually working as a nurse, you don't do any of those calculations. The pharmacy does it all for you. So what was the point of me doing all that math in nursing school? I mean, you do a little bit of math, but not like they led you to believe in nursing school. Come on, you guys, come back. I'm bored. Anybody want to ask me any questions? Want to talk about any topics? Judy, tell me more about Laura Owens. I wish Teamy would quit thanking me for buying stuff because they keep giving me gifts that are like, you can get this item for 1 cent. And then I go to the website and they're like, but you have to buy $50 gift. all three men she accused of getting her pregnant with twins. Okay, the dude from the Bachelor, was it the Bachelor or Bachelorette or whatever? Didn't she have like an ultrasound that she showed him supposedly? Where is she getting these ultrasounds from? We should all get up and oh, this is a good time to look for that. Now watch, watch. Now they'll come back. They'll come back. They'll come back as soon as I try to start. For it. How do you alter a sonogram? So where is this? Like where where is she? Where is the case happening? Being guilty or not guilty? Or oh, she bought an ultrasound. Oh my god! That oh oh. Jill, did I send it to you? Or did you send it to me? The you sent it to me. The Judge Beth thing. Find it. Yeah, I don't watch The Bachelor. The only reason I know about her is because Law Talk with Mike was doing it. But I don't watch. I think The Bachelor. I think that because they're going out with all these women at the same time. They're kissing all over them. And who else? What else are they doing? Like, who knows? Yeah, might as well, because I can't find it. Oh, wait. It is a lot of scrolling. Yeah, can you send it again real quick? Because I'm scrolling and scrolling and scrolling and I still can't find it. Yeah, I can't imagine doing that to somebody. Ugh. He slept with all of them? Ugh. See, that's just, ugh, that's disgusting. Ugh, ugh. See, that's why I don't, why would anyone want,
That's your clean copies for evidence.
and now
Enter
they're,
your
see,
participant. Please enter the pass.
I knew that was going to happen.
You have joined the meeting as an attendee and will be muted throughout the meeting.
Please be seated, court is in session.
The host would like you to unmute your microphone. You can.
Oh, well. Still, go ahead and send it.
All right. I appreciate the time. I appreciate people's patience.
Yeah, I think
In reviewing Rule 2 purpose, it says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity and procedure, fairness in administration. Looking to Commonwealth 16, 2017, a judge, Robert Kane was the trial judge. So because none of the purposes here in Rule 2 are served by the admission of the Maryland trial judge's decision, particularly were offered without notice to the court previously, I'm excluding that decision. Your rights are saved, Mr. Alessi. We've got that decision, her methodology. So that's my decision. So bring the jurors in, please.
You are unmuted.
Chrissy, do you want this under that?
yeah, me too, Jill. Spike, what is your deal, dude? Oh, you can't get to me because the chair is there? Well, come around the other way. Where are you going? You gotta go outside? You need to go outside? You gotta go potty? Come on.
Court back in session, you may be seated.
Jurors, I appreciate your patience. So your next witness, Mr. Brennan?
Oh,
The Commonwealth calls Jessica Hyde.
well then how did she claim she was pregnant then? I hope she pleads not guilty and goes to trial so the whole world can see her stupidity. Did you say 7 felonies?
Follow me, please. Take the card and raise your right hand.
Please tell me, swear the evidence given to the court and jury in the case now and here, the truth, the whole truth, and nothing but the truth, so help me God.
Yes, I do.
Good morning.
Yeah,
Good morning.
I remember.
Morning, Your Honor.
I mean, I remember I figured it out. She was the one that was on that.
All right, Mr. Brennan, whenever you're ready.
Thank you. Good afternoon.
Good afternoon.
Could you please introduce yourself to the jury and spell your last name for the record?
My name is Jessica Hyde, Jessica space HYDE.
What do you do for a living?
I'm a digital forensics examiner. I'm also an associate, I'm also an adjunct professor at George Mason University, where I teach mobile device forensics in their graduate program. I also own a digital forensics company that does training, services, and research.
Oh my
In
God.
addition to teaching at Georgetown University, do you teach in other ways?
Correction, I teach at George Mason University,
I'm
not
sorry.
Georgetown. But thank you. I also teach, my company writes and develops training courses. I teach a mobile forensic analysis course and a data structures course there to law enforcement, civilians, et cetera.
Do you engage in any other type of academics or research?
I do. I do other research as part of some volunteer activities I do in the digital forensics field. So I'm the chair of DFIR Review, which created research so that it can go through peer review. I often do reviews as a member of a reviewer for Forensic Science International Digital Investigations Journal, which I was a previous associate editor of.
What does peer
Oh, I'm
review,
so sorry.
what does peer review mean?
Peer review means that when a study is done or a research paper is done on a topic, that an assessment is done of it. There are 3 types of assessments that can be done. One is a methodological assessment, where you read through the methodology of the academic or practitioner-created paper and state if it is acceptable or not. The second is you conduct your own testing using the same methodology to conduct a peer review with your own generated data sets. And the third is if the original author has shared their data sets, reviewing their data sets and checking that against their work.
Has any of your work been peer reviewed in the past?
I've had 2 peer-reviewed journals. I've had an article that was peer-reviewed and published in Forensic Science International Digital Investigations regarding the standardization of file classification of recovered items. The layman's term of that would be talking about what deleted means. And then I have another paper that's been accepted that I was a co-author on in terms of timelines and correlations of forensic evidence.
You mentioned you work in forensic data analysis. Generally, what does that mean?
It means that I look at evidence of digital forensics devices, be them mobile phones, computers, Internet of Things devices, and do analysis to provide meaning and context to the data that's recovered from them, as well as performing data recovery of those same computer-related devices.
Did you have any specific education or training to learn about forensic?
Absolutely. As I have a master's in digital forensics from George Mason University. a master's degree in that. I've taken multiple courses, advanced mobile analysis, iOS forensics courses from SANS, computer forensics courses from SANS. I have multiple certifications. I hold the GIAC GCFE, which is the GIAC Certified Forensics Examiner. I also hold the NWC 3CFE, which is a Certified Forensics Examiner.
Do you, through your company, teach other forensic examiners how to study forensic data?
Correct. I teach government agencies, both federal and state and local, how to do digital forensic analysis, as well as private sector digital forensics examiners.
Method.
I've developed an online virtual course that we teach virtual live, so I'm always there when I'm teaching, but I also have a team of instructors. So for example, the mobile forensic analysis course that I developed right now this week is being taught to a police department in Texas right this moment.
Forensic.
I personally specialize in mobile phones and Internet of Things devices.
I want you to just give us some very basic, very general and brief background. When you're looking at a forensic device and you're analyzing it, do you rely on any tools?
That is a really interesting question. Reliance on tools is not precisely what we do. We utilize tools to extract data from a device, and then we utilize a variety of tools to attempt to parse results from those devices. But the forensics examiner has to take the additional step to both understand, validate, and provide meaning to those results.
Is there any shortcomings or dangers in simply relying on a forensic tool for a result or an opinion?
There is absolutely a danger in just relying on parsed results. When an algorithm is used to determine what data is stored as, it doesn't tell you what that data means, and that's where causes the data to exist, and that takes deeper. Phone, you can go to millions of apps. There's like 6 million apps between the two stores. Digital forensics tools maybe support generously 1,000 applications. So in order to be able to parse and understand the data from applications that the tools don't know how to support, you need a forensics examiner who knows how to dig into that data, conduct testing, and determine the meaning of the data.
Were you asked by the Norfolk County District Attorney's Office to analyze that was related to a person by the name of McCabe?
Yes, with a very, very specific scope to a specific date range.
Were you asked during that scope and date range to analyze it and provide an opinion about whether there were any user-initiated deletions of any web searches or Safari type searches?
Yes, I was asked to look for deletions of Safari searches within the scope of the time frame that was dictated by the purpose of the exam.
Were you asked to look at the phone device and determine whether or not there were any user-initiated deletions of phone calls on the device?
Yes, I was asked to look for deletions of phone calls in that same date range.
And did you do both of those tasks?
Yes, that's correct.
Did you ultimately have opinions on both of those issues?
I do have opinions on both of those issues. That's correct.
And in engaging in the efforts to answer those two questions, did you necessarily have to review and analyze a web history that included searches on January 29th, 2022 at 2:27 a.m.?
I did analyze web searches that occurred at 2:29 a.m. In local time here in Norfolk on January 29th, 2022 from the device that was provided, yes. Not the device, the forensic image, for clarity.
So before we get to the two opinions that you were asked to consider or what your opinions were after analyzing the data, I want to begin by giving the background and having you share with us your analysis and your observations and opinions about the search on Safari relative to this 2/27 timeframe. Before we begin that, let me just ask you one question. Did you do anything to ensure the integrity of the data that you were looking at?
Upon receiving the forensic image, the first thing I did was I did what's called a hash of the image. So a hash is an algorithmic representation of a file. So a forensic image, all the data from the phone, it comes in one file that can then be extracted and have the rest of the data. That singular file that's received, there's actually 3, but focusing on the one that has all of the data, that archive file, you can run what's called a hash algorithm against it. There's actually multiple hash algorithms, and I hashed it, and then I validated that hash to the document that was provided along with the image file that contained the hashes that were contained in. Those hash values matched. Now, just for clarity, if you change one bit in a file, it will not have the same hash. So the hash provides integrity in that report and ran 2 different algorithms. They both matched. Additionally, I reviewed the PDF that was received for signs of alteration. The PDF that comes with a Gray Key report is not signed by Adobe Acrobat. However, I was able to take that PDF and then examine it just like I would a phone. So I'm using the same techniques on the phone. Using a tool called EXIF tool, I was able to learn a lot about the creation of that particular PDF. And what I was able to learn about it was that it was created by, it's labeled it as being produced by Grayshift using a particular code-based application to create the PDF called PYF, standing for Python Framework PDF. It is on, it's a program that you can download, and developers who create tools like Magnet Forensics, who owns a Gray Key, utilize that script, which is why it says it's produced by it, to create the actual PDF. That's what the evidence there in the data tells me. It also contains a time of when that is created, and that time was February 2nd, 2022 at global UTC, that's the global constant time, think what's in the UK, at 22:49, which local time would be 5:49 p.m. So that says that it was created approximately 2 hours and 45 minutes after the document said the image started, and it correlated with the document information. So that provided some level of certainty that that document was factual. And on top of that, I further opened the file of that PDF in what's called a hex editor, which lets me see like every byte, every 1 and 0. And from doing that, I looked for tag markers that are made sometimes in some modifications of PDFs called XMPs, which is Adobe's format of markup. And I did not find any evidence of those tags.
When you're trying to determine whether there's integrity in the data, are you able to tell whether or not there's been any alterations or tampering before the item is put on the Gray Key machine to make the extraction?
That would be when you're talking about if the physical device had been manipulated, is that correct?
Yes.
I cannot tell if the physical device has been manipulated prior to it being imaged. I can only validate if the image was correct. In theory, all of the data of anything that you did on that device would still show in the evidence of device logs and whatever locations that were touched or communicated with. But at that point, it's the same as any user interacting with the device itself.
After the phone's extracted or at the time it's extracted, does it have the history of the device on that extraction?
Could you rephrase?
Yes. At the time the phone is extracted and the copy is made in the PDF and the digital copy, does the digital copy and the PDF contain the history of searches and calls and other items on that phone?
The forensic image itself contains a variety of different artifacts or traces that are left behind by activities that a user does on a phone. Yes.
You use the term artifact. What does that mean in a basic sense?
An artifact is any type of evidence that is left behind on your phone of an action. So, for example, if you receive a call, there are multiple places in the phone that show that a call was received. That can be in the call log, that could be in a notification, that could be in a unified log that tracks the activity that the phone's doing. There's multiple locations, and each one of those residue of the fact that the call came in, that's what I would refer to as an artifact. So you could have an artifact not just about a call, about a web search, about taking a photo. Any action you take on your phone may create an artifact.
Before we get into those two questions about any alleged deletions from Safari, a Google search or an internet search, and any alleged deletions of phone calls, I want to start with your explanation or your sharing how the timestamp works relative to that search beginning at 2:27 a.m. on January 29th, 2022.
So for clarity, there's more than one search that happens actually at 2:27. There is some activity that's looking at, and I don't want to mispronounce the name of the town, I'll try Hockomock Sports, looking at activities for the sporting events at that school system, I assume, or county location. There is a timestamp for the search Ha's Long to Die in Cold. However, that timestamp isn't about active searches. It's about the time that a tab was either opened or moved to the background. So Ha's Long to Die in Cold is the most current search in the tab that you opened at that was opened at 2:27. So if you're using your phone and you go to your browser, you have some choices. You can just open an existing tab or you can open a new tab. A new tab was opened at 2:27 a.m. and that search was done there. Another tab, actually at 2:27, was moved to the background, and its last search at the time it was moved to the background was for, I believe it's Raining Men, the YouTube video. So those two searches both exist as what's called browser state searches, but that's browser state isn't about the time that it was searched. It's about the time that the browser tab that you opened either went to the background, or if it's never been moved to the background, the current search. So the time in the instance of the It's Raining Men video is the time that that video was moved to the background and the new tab took over as the tab that's active. And that tab, the last search done in that tab is Ha's Long to Die in the Cold, because that database holds the current search. It constantly gets updated, and the time that the tab was either opened if it's the first time it's opened, or moved to the background if it's an existing tab.
Did you put together an exhibit that would help explain some of the different databases?
I did put it together an exhibit that would show that.
May I approach?
Yes.
Handing you a piece of paper. Do you recognize that?
I do. This is table 1 from the first report I created on this case on the phone that I was told was for Jen McCabe.
Is that the exhibit that will help you explain?
It will.
I move this to evidence.
Could you approach that? Or have that bit of that if you want.
Okay, hold on. I wish they would quit saying the name of that song. It gets stuck in my head every time they mention it. I mean, I like it, but I don't like it when it gets stuck in my head. Like, quit licking the rug. Yeah, he licks the rug, he licks the bed. He eats paper to watch him. And he knows he's not supposed to. Because he'll sneak up real slow to the garbage can. And he'll do that side eye thing he does.
Before we look at any chalk, I want you to explain the entire basis for that chalk and your ultimate opinions that are reflected in the chalk. So let's start from the beginning.
May I
And,
look at my copy of the chart or no?
Why don't I just
Your Honor,
ask you,
may I?
See if you can answer the questions and if you can first.
Yes, Your Honor.
when you looked at the phone to analyze it, were you trying to determine when a particular search was made, specifically the search, how long to die in cold?
Correct. I was looking for two searches, both how long to die in CIKD and how long to die in cold.
So as a forensic examiner, how do you begin the process to try to identify and determine when that search is actually made?
So the first thing we would want to identify is what application was being used at the time to make the search. So looking at that date time stamp, it was able to, on that date, be able to determine browser. And then you would begin looking at the artifacts for Safari, both those that are parsed by the forensics tools, but then further looking into the data structures that hold that data itself, and then a certain artifact exists.
So you mentioned you begin, the beginning step is the forensic tool or tools. Did you use forensic tools to get information or parse any data regarding this potential search at 227?
Yes, I use multiple forensics tools.
Can you share with us the multiple forensic tools that you used?
Absolutely. I used Celebrate Physical Analyzer. I used Magnet Axiom. I used just a few, but those were the three that I started with.
What tools did you use later?
Later, I used specifically, I've used Sanderson's Forensics Toolkit, the forensics browser in Sanderson's Forensics Toolkit, which helps exploit SQLite databases. And then I further reviewed in a tool called Rabbit Hole.
To begin with, Celebrate, is that a tool that you're familiar with?
Yes.
Is it a commonly used tool in the industry?
Yes, commonly used mobile forensics tool.
Is it reputable?
Highly reputable.
Why did you use Celebrate?
I use Celebrate because on any mobile exam, I'm going to validate what is captured by Celebrate and Magnet Axiom because they have the most robust parsing of what is in my tool arsenal. And then I would also follow up with iLeap closely behind because iLeap has a lot of artifacts that aren't supported by either of those tools. Using a variety of tools is going to give you different coverage. And
you said you also use Magnet Axiom?
That is correct.
Is that a leading forensic tool as well?
Yes, that is also a leading forensics tool.
Are you familiar with that company?
I'm very familiar with Magnet Forensics. I was actually their director of forensics for 5 years, then continued to consult for them for an additional 2 years under my company, Hexordia, and my company continues to be a reseller of Magnet's products.
Right. Do those tools change the underlying data at all?
That's a great question. So when we're talking about the results that a tool shows, the tools maintain the integrity of that original forensic image. And that's actually something we verify as we continue through our exams to make sure that the underlying data hasn't been changed. There are some tools, I did use some other tools, I apologize. I also used ArtX and Mushy. But ArtX is capital A, lowercase RT, capital E, lowercase x, and then Mushy is MUSHY. You're welcome. I'm sorry, can you repeat the question? I got this, the spelling threw me off.
I mentioned, or I asked you about using multiple tools and whether or not the use of different tools changes the actual underlying data.
So the actual underlying data is always maintained, and we do validate that. Some tools allow you to see parsed results and then allow you to dig deeper into looking at the actual files and data structures. Those would be tools like Celebrate, Physical Analyzer, and Magnet Axiom. Some tools show you the parsed results and tell you where they got them, like iLeap. It shows you the parsed results and tells you the file location, and then you would open that up in an external tool. And then some of the tools I used are not tools that parse the results, but are tools that allow me to manually look at the data structures. So they directly allow me to look at the data structures. And all of the tools I use in this instance are tools that do not change the underlying data.
Is it important or critical to go beyond the tools presentations and actually analyze the data yourself?
It is absolutely critical. Actually, in the NIST Scientific Foundations paper from the National Institute of Science and Technology that states the foundations of digital forensic science, it states that it is the examiner's duty to not only verify and validate tool results, but also to provide meaning to forensics parsed results.
Does software update regularly?
Oh, the software updates all the time. Typically, we get an update about once a month. And to be honest, it's not enough to keep up with how many new apps are developed and how many new phones come out and how many of your applications get updates, new features, for example, maybe in Instagram or Facebook. So the tools update very, very regularly.
When you use the Celebrite tool to analyze the 227 search, did the search "How's Long to Die in the Cold" have a timestamp on it?
There are actually multiple artifacts for "How's Long to Die in Cold." Remember earlier we defined an artifact and we spoke about it was one of the types of traces. So there are multiple traces for that "How's Long to Die in Cold." Only one of them is associated with the 227 timestamp, but there are other instances of evidence of that was parsed by Celebrite.
Is there any danger for an untrained eye to rely simply on the software when looking at a search like this, "How Long to Die in the Cold," and seeing the 227 timestamp?
Absolutely. There's a really scary danger that an examiner who has not dug into the artifact and tested to see what it means may assume erroneously that that 227 timestamp is the time that what is there is searched. The search in that field of that artifact is going to always be the most recent search in the tab, but that timestamp actually means either the time that that tab was backgrounded or if it's the first time the tab's been opened, when it was opened. So you could erroneously implicate a search was done hours or some time period or even days before it actually occurred. Some of us leave our tabs open forever.
In your teaching, examiners and students, do you teach about this specific concern and concept?
Yes, I teach about this concern both in my mobile forensic analysis class, my mobile forensics course that I teach at George Mason University and their digital forensics master's program, and in the data structures course where we specifically learn how to analyze these databases in question.
In your experience, how common does an untrained examiner make this mistake?
I wouldn't be able to speak to how common an untrained examiner does it, but regularly my students get those questions wrong on earlier examples I give them in class to kind of indicate to them that they could easily make mistakes without understanding meaning, and I use this as a teaching aid. So teaching, 90, 100 easy students a year, I regularly see that in untrained examiners that I'm teaching in my class, but I wouldn't be able to say that across the discipline.
You mentioned that Celebrite showed the search on the report as "How's Long to Die in the Cold" with a timestamp of 227. Is it 2740?
Yes, that's correct.
Do you know whether or not Celebrite has updated its software?
In May, Celebrite of last year, Celebrite made an update to their software actually to remove this artifact because of its ambiguity and the risk that an examiner may overstate or misstate what it is.
Is this ambiguity reflected in other types of software?
Could you rephrase, please?
Sure. For example, when you did a report in Axiom, did it have similar reflection in the report?
Objection, Your Honor.
Ask it differently.
Did you run a report regarding this time frame through Axiom software?
I did process the image through Axiom, yes.
When you did that, was it the same or a different result?
Axiom and Celebrite really show their data very, very differently. So Celebrite takes a perspective of alerting people to possible deletions by annotating either a question mark or a red X next to artifacts that come from different areas. Magnet instead marks if the artifact was parsed or carved. I feel like now I need to explain to you parsed or carved. So parsed means that the data was where it was expected to be found, and the algorithm was able to cleanly see that this is there. Carve means that it had to run that algorithm against the data structure as a whole and found it as a partial result. So it carved it out and went and found it instead of it just sitting there exactly where it was expected to be, and shows you both the results. So it'll show all of the results of, in this instance, the sessions, tab browser DB, the tab state. It's going to, instead of telling you this has a red X, it'll instead say it was carved. So it's a different presentation of the same data.
So I want to talk about deletions in a little bit, but I want to get back to the 227 search.
Sure.
So when you produced or you looked at the report for Celebrate and it showed this timestamp as well as the phrase, "How's long to die in the cold," where did you look? How did you make an analysis to determine whether or not that search was actually made at 227 or another time? What was your next steps for us?
So in looking at that timestamp, the first thing I did was actually go and look at what literature exists on the artifact, if anybody had reviewed this artifact before. I also created my own data set and tested how we could get what that timestamp means. So if I make a search in a tab and then I make another search in the tab, which timestamp is it? If I make a search in a tab and then open a different tab, what changes? I also looked at the documentation in the artifact reference guide for Axiom, which does state, it describes that timestamp as the time in which the tab is backgrounded. And it gives a stipulation that in certain circumstances, the timestamp can be earlier than the search.
Did you specifically look in any databases or for artifacts in the data to help make an analysis of when this search happened?
Of when the search happened as a whole? Absolutely. So there are multiple databases that I looked at that show search information for Safari. So I looked at the plist, mobile Safari plist. I looked at the browser state database. I looked for the history database. I also looked at the Knowledge CDB. The Knowledge CDB is a little bit different. That isn't a database for Safari. It's a database for all of Apple, so it can predict your behavior. So it takes in information that Apple wants to take in, including browser history, and it saves that information so it can make predictive information. I also looked at the caches in the Safari, which is the things that Safari is trying to make quick reference to. This would include suggested terms for commonly searched items.
When a URL or a search through Safari is typed in, or if it connects, does it leave a trace in different parts of the computer or of the phone?
Yeah, so when you actually do any search, you're going to leave traces. Now, it does depend if you are in private browsing or non-private browsing. So non-private browsing is what most of us use regularly. Private browsing might be what you elect to use. Well, some people would elect to use it if they're doing searches they wouldn't want their spouse to see, like maybe they're looking at porn, or maybe you're doing something secure like looking at your banking information. You may intentionally use a private browser. For Google users, this would be the equivalent of incognito in Google Chrome, and you may intentionally use that. And so the artifacts for that are more limited than the artifacts for non-private searches. So some of these artifacts only exist for non-private searches, and some exist for private searches.
And in this case, this phone, was it on non-private or private?
So specifically the two searches we're talking about, how's long to die in cold and how long to die in CIKLD, excuse differentiation there. Both of those searches were done. I don't understand the question yet.
Was there any applications on to mask those searches?
Not to the best of my knowledge. I did not see any.
We began with the 22740 timestamp. The next recording on that tab, do you recall what time that was?
I believe the next, and I'm trying to remember the chart from memory, if that's correct. So I believe the next thing we're looking at is the 623 suggestion from Apple search terms for how long to digest food. Am I matching what you're seeing on your chart?
Well, let me ask you.
Okay.
When you saw that, do you look on the same tab or a database? Where do you find that information?
Fair. Understood. So all of those databases I was just mentioning before, we're looking at all the parsed results from all of those. And I was looking in the entirety of the scope from the time of midnight till noon. That was the time frame of my scope of all of the content that was done in the tabs for browser state DB, cloud tabs, artifacts, History DB, Mobile Safari plist, Knowledge C, each one of those. And then I was combining them to timeline out the activity.
At 62351, did you look into how long TIDIE in CIKD?
So that would be the next thing that we see after the Apple suggested term of how long to digest food. That's the next thing we see an entry of that. There's two immediately next to each other. I don't remember the precision on the seconds of which one's first off the top of my head, but one is in Knowledge C and one is in the Mobile Safari plist.
Can they appear in different rooms in the data bank in different places, the same search?
Searches appear in many different places. They can leave traces, such as that Knowledge CDB. I love that Apple calls that knowledge. It's like what it's trying to learn. So the Knowledge CDB, what Apple's trying to learn about you, as well as in that Mobile Safari plist, as well as at the moment of that search, which I don't have the device in that moment, but just so there's an understanding, that open tab, the URL would have been updated, or URL is the website, would have been updated to that search at that moment. Had we imaged it at that moment, it would have been how long to die in CIKD.
And finally, at 62447, did you identify any artifacts with that search that appears with the timestamp of 22740? Did you find the same?
Correct. At 624, we have two timestamps in the same two locations for how long to die in cold. The Knowledge C and the Mobile Safari plist.
So based on your analysis in that issue, did you come to an opinion whether or not the phrase "how's long to die in cold" was actually searched at 2:27 a.m. on January 29, 2022?
There are no artifacts.
So the answer is yes or no?
Can you repeat the question,
Yes.
please?
And so based on your analysis of the phone and the data using all of those softwares, did you come to an opinion whether or not the phrase "how's long to die in cold" was searched at that timestamp tab of 22740?
Yes, I came to an opinion.
And what is your opinion?
Objection, Your Honor.
Rephrase the question as to the opinion.
I'm sorry?
I'll see you at side also, Mr. Leslie.
Thank you, Your Honor.
What now? So why did you say darn it? I'd play it now, but I don't know how long they're gonna be out. Oh, did you say darn it because they came back right as we were gonna play it? I need a soundboard like Matt Rouse so I can do the witch's cackle he does. I love that stupid witch cackle. Funny. Why are you barking? I have a headache. No barking. Belle, I thought you didn't like plain crackers. You usually only want them if they got peanut butter on them, and then you lick the peanut butter off. Okay, last one.
Because both sides don't. But would everybody like to get up and take a stretch?
Well, I don't have a soundboard, so it wouldn't help me.
Everybody like to get up and take a stretch? Attorney Jackson, do you need 5 minutes? Can we do 5 minutes? Okay, we're gonna stretch. I'm gonna have the jury get up. I've been practicing for Pamela Pumpkin. Are you ready? Brennan to the left, Jackson to the right. Stretch up, stretch up, stretch up. Shake off, skip up, shake up, shake off, skip up. Okay, this is
Ugh, it's not gonna work. Never mind. I'll try to get it to work later. I'm just being stupid. Quit barking at me. I have a headache.
Analysis. Is there a methodology that you use, not just looking at the print out of the programs, a methodology you use that is accepted in the data and comes to your opinion?
I further looked at those databases independently and conducted testing of the artifacts.
And in addition to what you did, can you share with us how and why this methodology is accepted in your practice as forensic analyst?
This methodology is accepted by NIST and by organizations like the Scientific Working Group of Digital Evidence. I'm intimately familiar as both a member of the Scientific Working Group on Digital Evidence, who helps work towards the building and development of these consensus-based documents of procedures to be followed in digital forensics analysis, and as a member of the National Institute of Science and Technology, NIST, Organizational Scientific Area Committees, OSAC, Digital Evidence Subcommittee, where we also produce guidelines such as the data set guidelines for generation of the guidelines for data set generation, which is how you do your actual testing and creation of data sets. And I was also a part of the subcommittee that drafted that. So I'm intimately familiar with the accepted policies and procedures because I am also a member of the groups that help author these, as well as review them and look and use them.
Are there articles and guidance in the industry about this particular practice of analysis?
For analysis, just for clarification, you're talking about for analysis of Safari artifacts, of mobile forensics, of browser state DB, just for clarity on the question.
Let's work our way through it. How about
Sure.
through Safari?
For Safari, there are multiple different blogs that talk about Safari, as well as I have analysis of Safari through classes I took, such as SANS 4508, which is their, 518, SANS 4518, which is the Mac and iOS analysis course, which I took.
How about the specific guidance regarding searching the different databases for artifacts?
In terms of methodology for digging into databases,
Yes.
Is that correct? There are multiple, I've taken courses throughout my master's program courses on how to analyze digital forensics artifacts, including mobile device forensics, throughout my GIAC certifications. I've taken multiple instructor-led courses on how to do these, as well specifically that cover mobile Safari history in mobile forensics at GMU in his master's program as part of the SANS 4518 class. And in terms of data structures, I've taken study on how to analyze databases like SQLite and PLIS are covered in those courses.
There are books on study on this methodology.
There are multiple books on digital forensics, many of which I've read, and including books specifically on analysis of SQLite databases, such as Sanderson's SQLite Forensics, which is probably the most authoritative because not only was it written by Sanderson, who makes a tool, it was tech edited by 3 renowned forensics examiners, as well as Dr. Richard Hipp, who created SQLite itself.
The methodology, the technique you use to look past the reports and actually look at the data to make your determination and arrive at your opinions.
Absolutely. Again, using the methodology from the consensus-based documents from the community, from the Scientific Working Group Digital Evidence on best practices for analysis, as well as specifically for the SQLite databases I was looking at. I do that deeply verifying and in accordance with the understandings from Sanderson's book.
Now, you share with us that you had an opinion regarding the timestamp and whether that it was applicable to the search term "How's long to die in cold."
That is correct.
Now, I want to ask you, to a reasonable degree of forensic data, scientific certainty, what is your opinion about whether the phrase "How's long to die in cold" was made at the time of the timestamp 2/27/40?
It's the last time, Mr. Massey, on this issue, okay?
Good Lord, people. Because both sides are shut. But would everybody like to get up and take a stretch? Attorney Jackson, do you need 5 minutes? Can we do 5 minutes? Okay, we're gonna stretch. I'm gonna have the jury get up. I've been practicing a camel of pumpkin. Are you ready? Brennan to the left, Jackson to the right. Stretch up, stretch up, stretch up. Shake off the Skittles, shake off the Reese's. Shake off the Skittles, shake off the Reese's. Ride the witch's broom. Ride the witch's broom. Nice little stretch. All right, back to work, everybody. I'll see you inside there. Jurors, I know this has been a hard day for you because both sides are shut. But would everybody like to get up and take a stretch? Attorney Jackson, do you need 5 minutes? Can we do 5 minutes?
Okay, we're gonna stretch. I'm gonna have the jury get up. I've been practicing a Pamela Pumpkin. Are you ready? Join it to the left, jump to the right. Stretch up, stretch up, stretch up. Shake off the skittles, shake off the receipts, shake off the skittles, shake off the receipts. Ride the witch's broom. Ride the witch's broom. Nice little stretch. All right, back to work, everybody. I'll see you right there. Jurors, I know this is a hard day for you because both sides.
There's your fan, Ardo. It was on the lamp a minute ago, but it switched over to the fan. For something, I give it to him. Wow. $10 was a crap. Like $250. I believe my husband would do that for Christmas. But this Christmas, I want that new Switch. Jill, are you getting the new Switch? There's supposed to be a new Zelda game coming out for it. There's a new Zelda. There's going to be a new Zelda and a new Mario Kart, I think. But I don't know if they're going to.
All right, go right ahead, Mr. Brennan.
I'm now going to ask you for your first opinion. So you shared that you have an opinion about whether that timestamp 22740 was, whether or not that was the time the search how long to die in the cold occurred. Can you tell us to a reasonable degree of scientific certainty your opinion about whether that search, how long to die in the cold, occurred at 2:27:40 a.m. on January 29th?
Actions overruled.
What I can state to a scientific degree of certainty is that that search occurred at 6:24 a.m. and was the last search in the tab that had been opened at 2:27.
Do you have an opinion to a degree of scientific certainty on searches similar to?
I'm going to allow it.
May I first inquire, you meant morning? I
Sorry,
assume?
that morning. Yes.
Just clarifying, I did not look at evening searches. And can you repeat? I apologize. I disrupted my own train of
Do you have
thought.
an opinion to a reasonable degree of scientific certainty whether there were any other searches on that tab before the final search at 6:24:47, how long to die in cold?
Overruled.
That I have the question correct.
Please.
You're asking if what else occurred in that tab prior?
Yes.
That I cannot say with a clear degree of certainty.
Okay. Did you?
Yes.
Again, I show you. Same document, you recognize it?
Yes.
What is it?
It is the exhibit that I created that was labeled Table 1 in the first report I had delivered.
Understanding your opinion.
Yes.
I move subject to redaction that this be introduced into evidence.
I have no issue regarding that.
Madam Clerk, 82?
Exhibit 82.
Thank you. With the court's permission, I'd like to show Exhibit 82 to the jury.
Okay.
Could we enlarge the first two? And we're going to need to get the right column in if we can, please. Thank you. Ms. High, can you see it from there?
I can. Thank you.
If you can walk us through how this exhibit assists us in understanding your explanation and the basis for your opinion.
This exhibit shows the Safari artifacts and artifacts of Google searches in Safari related to the two searches in question, How Long to Die in CILKD and How's Long to Die in Cold, that occurred on the morning of November 29th, 2022 on the device under examination.
If I look at this chart and I see in the top left, it says 2:27:40 a.m. And then under the search term, it says, How's Long to Die in Cold. How do I understand your opinion that that search didn't happen at 2:27:40?
This document is showing you the data that is the parsed result. The source of that artifact that you see in the last column is a little bit cut off, the browser state db-wall file. That database does store, how the data is stored, the search term How's Long to Die in Cold with an associated MAC absolute epoch timestamp that translates to 2:27 a.m. That is what is physically stored. That does not annotate the meaning of that artifact. That was determined through testing following the NIST OSAC data generation guidelines for testing.
In the second row, we see a timestamp on the left-hand column, 6:23:49. And it provides artifact, the cache record.
Mm-hmm.
What is the term? And what does that mean under the search term?
iOS Safari cache records. A cache refers to something that a computer program wants quick and easy access to. When we search on our phones, anything, a lot of times, be it in Google or in Safari, depending on what type of phone you own, it'll suggest what it thinks you're going to type in, right? So you can click it. It's trying to be helpful. In this instance, at 6:23:49, we have a cache record that indicates that Apple suggested the phrase, how long does it take to digest food?
And then under that, 6:23:51, it appears it says a recent web search, and the spelling is changed. How long, TIDIEINCIKD.
So this, in reference to these two search terms, this is the first actual search that occurs at 6:23:51 a.m. Upon beginning the typing of that phrase, Apple provided the suggested search, and the person inputting into the phone at that time continued to type out a phrase and finished it as how long, TIDINCIKD, which that is available to us in the mobile Safari P list, which tracks recent web searches. And then we'll see 6 seconds later, we get that reference in that Knowledge C database that I mentioned before. That's the next line. So that's the Knowledge C database is Apple's way of keeping knowledge about what the user's doing. It sees and holds your knowledge. It's an easy way to remember it. That's what I teach my students. So that Knowledge CDB tracks a lot of things for predictive purposes. And so 6 seconds later, it's logging that same search. So that search is being tracked in 2 places.
And so one search can be left as artifacts in different locations on the database?
Correct. There can be multiple traces or artifacts of the same user action in different places on a mobile device.
And if we go down to the bottom, the last column, at 6:24:47, we again see How's Long to Die in Cold. And if you look in the first column, it's the same phrase. Is that a coincidence that it appears at the bottom at 6:24:47 and also appears up at 2:27:40?
As mentioned before, through testing of the artifact for browser state DB, that artifact will hold the most recent search that happened in the tab. So it is logical that HOS long to die in cold, was searched at 6/24/18, tracked in that mobile Safari P list, repeated in Knowledge C, Knowledge made its tracking in Knowledge CDB, and then that table for browser state DB, which again has the time that the tab was opened or the last time it was backgrounded, and updated just the website that was visited. So the website, that is why we get that 227 time. That's actually, as far as the data storage is, the first thing I have in there, because I want to put it in chronological time order for exhibit purposes, is actually the last thing to happen because it's the update to what's in the tab.
You offered that the how's long to die in cold is the last thing to happen. Do you have an opinion to a reasonable degree of scientific certainty the time when that search was made?
Objection, Your Honor.
To a reasonable degree of certainty, I can say that HOS long to die in cold was searched at approximately 6:24 a.m.
Now, moving on from the 227 search, there are two other issues that you were asked to analyze. We talked about them at the beginning. Let's begin with whether or not you looked at the data and analyzed the data and came to any opinions about whether that phrase, "how long to die in cold," was user deleted on that device.
So there's two really key elements as to if that was user deleted. If the question is, did I come to opinion? Yes.
And
I'm
can
good
you
to-
explain how you came to an opinion that will ultimately share with the jury?
The first line in that exhibit, the ending of it, if you remember, it said browser state.db-wall. That's important. Up is kind of how the database works, because I didn't just look at the tool result. I extracted that database and I did a deeper analysis on it using Sanderson's tool, because that information which is a specific way of storing, very, very common on mobile phones, actually one of the most common. When that database stores data, it has two versions. The most recent version, and the version in use here, uses what's called a write-ahead log. So before data is committed, it is written to a write-ahead log. I'll kind of explain it. So let's say we're in a restaurant and we're sitting at a table and we're ordering food. Our table is the table. Data is going to come to the table, and that's going to be our food. So when we order food, let's say we've got a chicken sandwich, a burger, and a pizza coming to the table. The chicken sandwich, the burger, and the pizza, the kitchen puts it in the warming area. It's the write-ahead log. The server grabs it from there. It's where data sits before it goes to the table, just like your food goes to that serving station before your server brings it to your table. Server brings it to the table. That table's got its burger, its chicken, and its pizza. Another table orders waffles and pancakes. They think it's breakfast. The waffles and pancakes are made by the kitchen. They're put on the serving area. Waitress comes over. This pizza has pepperoni. I don't eat pepperoni. Can you send it back? Waitress picks up that pepperoni and sends it back. That's a deletion. Pepperoni pizza was just removed from the table, right? We're deleting it. We said it's not what we wanted. The waitress is removing it. She brings it back to that serving area. At that moment, that serving area has the deleted pizza, but also the waffles and pancakes that are waiting to go out to the table. That's how a write-ahead log works. Any changes that are happening sit in the write-ahead log until the database is closed, and then when it's reopened, all those changes are made, both additions and deletions. So often when a phone is imaged, when we make a forensic image, the applications are still open, so we have those WAL files. When we look in our Safari browser, the database knows to read it to you in its current state. So it tells you where the waffles and pancakes are going. They're going to that table. So it shows it as if it's in the table, but it's not in the table yet. So if when we parse the data and we look at the restaurant and we don't look at the back kitchen, we would only at that time see the chicken and the burger, right? Pizza got sent back, waffles and pancakes haven't come out yet. So when we get the data, we get two files. We get the restaurant, that's the database, and we get the serving area, that's the wall file. Just because it's in the wall file does not mean it's deleted. It means that that record wasn't where it naturally sits yet. It could be that wall file can contain deleteds and food or data that hasn't yet been delivered to the database. So the wall file is both. So an assumption that the data just because it's in the wall file is actually not true. And the peer review paper I mentioned earlier that I had accepted in Forensic Science International actually has a section that explains this exact presence for SQLite databases about how we refer to that as recovered and not deleted. Actually, through that entire document, we don't use the phrase deleted. We refer to things in statement of recovery because we need to determine why it's there. So we can't say that it's deleted just because it came from the wall file. Some tools will automatically indicate to the examiner that they need to dig deeper into that. I did do further analysis by looking at the wall file. That particular item is a little bit more complex, actually exists on multiple pages because it moves as the database is being created, but all of them have the same unique identifier. So it's the same entry. It's not more than one search of Haslong to die in cold. If there was more than one search that had occurred where it became the top element in that database, we would see that. There are, as I mentioned, other carved from the database, from the wall file elements such as the search for the YouTube video, It's Raining Men, because at some point that was the last viewed item in a tab when that tab was retired right before, also at 2:27 a.m., but a couple of seconds before the Haslong to die in cold search. So we can see that that table is put to the rear. The newest tab that's open, which is why it's in the wall file, it's the most recent thing because it's like our waffles and pancakes hasn't been delivered to the table yet. So it can sit in the wall file for that reason. That doesn't indicate it's deleted. The second reason is there is no user interaction in a tab in that database, but you cannot delete a tab. There's no, if you were to pick up your iPhone, I know you don't have them right now, but if you were to pick up your iPhone and look, that wouldn't be a physical option you have in the interface. So it could not be deleted by a user through the interface for that most basic reason.
So a user, could they delete a tab if they wanted to?
There's no actual option to delete a tab. If for your web history, you could clear the cache, for example. Most of us are familiar in your web history. You might do it because you don't want your kids to see what you searched, or maybe your kids don't want you to see what they searched, so they'll delete it. But you can't delete the tab history. It's just what tabs are there. The device is tracking that.
When you looked at the software, whether it was Axiom or Celebrite, when you look just at the report, not the data itself, noting that that web is deleted?
The tools, Celebrite denotes it with a red X, which means that it is recovered. Axiom indicates that it is carved. In the same paper that I referenced earlier that I authored, there's a chart in there that shows the distinction between how different tools, some will use red X's, some will use question marks, some will list that.
Off with celebrate or carved an axiom should
An examiner should never assume something's deleted without doing a manual examination.
The manual examination, is that a method that's used, that's generally accepted in the forensic data?
As the data set generation guidelines both speak to conducting testing, verify and validate, and it states clearly that an examiner is to verify and validate findings and to determine meaning.
So given that you use multiple tools to look at reports regarding this phrase, how long to die in cold, and have seen indications or characterizations of recovered and carved, and in addition to the fact that you actually analyzed the data, did you arrive at an opinion to a reasonable degree of scientific certainty whether or not the user deleted, any user deleted the phrase, how long to die in cold?
Yes, if it's how's long to die in cold. Sorry, trying to clarify.
Pardon me. Did you come to an opinion to a reasonable degree of scientific certainty whether any user deleted the phrase, how's long to die in cold?
Yes.
And what is your opinion?
My opinion is there was no deletion that occurred by the user because it is not something a user can delete.
Finally, I want to ask you about your analysis of the phone records on this phone attributed to Ms. McCabe. Did you go through an analysis of the phone logs and the phone record?
I analyzed the call logs and the phone logs on the device that I was given, that I was told belonged to Ms. McCabe, yes.
Would a suggestion or a claim that a user deleted irregularly a number of phone calls, would that be accurate or inaccurate in your experience?
It is inaccurate in this instance. Yeah, this is what it appears in the forensics tools and additional artifacts that I looked at that are not parsed by the forensics tools. So the call logs, when you look at it, it appears, I don't remember if it's 8:57 or 8:59 a.m. in my mind at the moment, but approximately either 8:57 or 8:59 is the earliest phone call we see on the 29th of January. We see no call logs before, but we do see FaceTime logs before. So if an examiner, again, was making assumptions without testing or reviewing, the first assumption might be, well, things must have been deleted because there's data that exists before, but not current data. So then you have to go, how do phone logs work? And again, create test data and review. What the situation here is that there are 3 types of call logs on this particular phone. There's regular calls, incoming and outgoing. There are FaceTime video chats, incoming and outgoing, and FaceTime audio chats, incoming and outgoing. The storage for that is actually 200 records. So you can only store up to 200 of each. Now, if you were a user of, let's say, WhatsApp or Signal or Telegram, those would each count 2 and they'd get their own logs. So when we look at the database for the number of calls between 8:59 a.m. or 8:57, again, I apologize, I'm not looking at that precise time, on the 29th of January in 2022, there are exactly 200 calls still in that record from then until the imaging of the phone. There are 199 FaceTime video calls and only 27 FaceTime audio calls. So the question is, how do you validate that that's what's happening? So we actually have call logs that we can pick up in other places for recent call logs in the last 7 to 30 days, depending on the exact version of the device and how the biomes are running. We can actually see incoming call logs, the number they go to, and if they're incoming or outgoing in the biomes. So we actually can see the history going back for the entirety of that day on January 29th till midnight. Again, my scope was from midnight until noon. So we can actually see all of the calls. They're just not on the call history state DB. Now, the call history state DB, from a user perspective, that button on your phone doesn't say call history. It actually says recents. And what it's determining as recents is the most recent 200 of each category. Now, how did I determine this further? There is a running log that exists in a phone. It lasts about 3 days. It's called the unified log. The unified log tracks multiple things that are happening on the phone. In manual analysis of the unified log from this phone, I can clearly see each time a 201st call comes in, the 200th call gets deleted. So it's constantly just the last 200 calls. It may not be typical that we see 200 calls in 3 days, but on this device, we do see 200 regular phone calls in the 3 days between 8:59 a.m. on the 29th and when the phone was imaged.
So do you have an opinion to a reasonable degree of scientific certainty whether there was any user deletions from the phone call log that morning?
Yes.
And what is that opinion?
The opinion is that I can see that it's done by the device itself utilizing unified logs, that the system is deleting the 201st call every time a new call is received or outgoing.
Thank you. I have no further questions.
All right, can I see Councilor Sibar regarding scheduling and a few things?
Why are you worrying about a scheduling issue in the middle of a witness? Good Lord, woman. No regard for the jury's time at all. She says she does. Does she really? It's so rude. The judge in the Melody Ferris trial, he got so mad at the lawyers for wasting the jury's time. He got so mad he stormed off the bench one day.
All right, Ms. Hyde, I'm going to let the jurors have lunch. You can walk out after the meeting.
Thank you.
Lunch too.
Thank you, Your Honor.
45 minutes.
Thank you, Your
Jurors
Honor.
will recess for 45 minutes for lunch.
All rise for the court, please. Jurors, close your notebooks, follow me.
Oh my God, you don't know the Melanie Ferris case? Melanie Ferris. Oh man, we might need to do a wee watch. Yeah, let's do a wee watch. Oh. Let me tell you. What time are we supposed to be back? I probably look hideous. I got the lights off because of my headache. It is now turned into a migraine, guys. And I don't know why. I've not had a migraine in years. But my neck, this side of my neck is really tender. Like, this side's fine. It doesn't hurt at all. But this side right here. Melanie Ferris, there's a 48 Hours episode about this. So watch the 48 Hours episode. Melanie Ferris, she killed her husband. She shot him. And then she put him on the burn pile. She burnt his body. She had 4 kids, 2 boys and 2 girls. And the 2 boys and one of the girls believed that she did it. And one daughter believed her. Yeah, yesterday, towards the end of the day, my whole arm was hurting. But my whole head was hurting too. Through the back. And like the whole head was just like pressure, like my head was going to explode. It wasn't a migraine yesterday. It was everywhere. And like I said, my arm. But now it's just my neck right in here. And like this, like right in here, like a migraine. So I think it's coming from my neck. I don't know what's going on. So Melanie tried to pin it on one of her sons. I can't remember if it's the oldest or the youngest. So at her sentencing, instead of, people were laughing and saying that she listened to Sarah Boone's sentencing and was like, hold my beer. Because in her sentencing, she blamed her son. She begged the judge not to send her to prison, to reopen the case and investigate her son, that her son did it. Oh, Ardo. Yeah, I need to go to a dentist too, but I don't have dental insurance. I'm losing all my back teeth. They're just like, that's from diabetes? I didn't know diabetes did that. That's probably why I'm losing all my back teeth. And that's why I've got these faces. Because I had braces when I was a kid. I used to have pretty straight teeth. But because I'm losing the ones in the back now, these are going crooked again. Yeah, so she blamed her son. So the whole trial was like all this family drama. So she had an affair. Her husband was an attorney. He had an affair with somebody that worked in his office. She had 2 affairs. The first affair she had was with her husband's sister's ex. So this woman never married the man, but he had been her boyfriend for years and years and years. So he was basically like an uncle to her children. So that was her first affair, with this person that had been at their house for family gatherings and things forever. So she basically had an affair with her kid's uncle. Then the other guy she had an affair with was her cousin's stepson. Okay, so I watched this on... Judy, did you watch this trial with a recovery addict? Because this was right before I met Judy. Because I watched it on Recovery Addict's channel. He actually became not only mentioned in the trial, but evidence in the trial. Believe it or not. This is what was so funny. So the gun... Okay, Martha Jane, that was her name, Martha Jane. So her cousin, that was the stepmom of her boyfriend, he lived in another state. Like, the next state over. I don't even remember what states. It's been a while. So she would go visit her. And this woman's gun went missing. So one day, RA said something like, that's it. I cracked the case. She got the gun from Martha Jane. So Martha Jane happened to be watching the trial because someone told her that the trial was on YouTube, and she thought she was watching court TV, I think, but she was watching RA. She was watching Recovery Addict. So when she heard that, she was like, oh my gosh, my gun went missing, and that's where it went. I have to call the cops. So she called the cops. She wasn't even on the witness list. She calls the cops. They put her on the witness list, or the DA's office or whatever. They put her on the witness list. She gets on the stand. So they're asking, then they start asking her about watching the trial. Because, you know, they always do that when you get a witness, like in the middle of the trial, it just out of nowhere shows up. They ask you, were you watching the trial? And she's like, well, yeah, well, where were you? I don't know. There was this little man down in the corner. So now we call Scott the little man in the corner. And it's still so funny to me. I can't help it. So there's a printed out sheet of like a screenshot from Recovery Addict stream with a picture of Scott down in the corner that is actually a piece of evidence in that trial that the defense attorney held up in front of the jury during closing statements or closing arguments. I can't help it. It's just still so funny to me every time I think about that. I was like, Scott, is this the first time you've ever been evidence in a trial? He goes, nope, second. I don't remember what the first was, but now we tease him. We call him the little man in the corner. But she was the only one home whenever it happened. Everybody else had an alibi. But the big thing that everybody got hung up on was how did she get him to the burn pile? Drag him? I was on an incline. Let's see in the corner. Yeah, so and that trial, I mean, it was horrific, but the thing about that trial that will always stick with me is Scott being part of it. Oh my gosh, that's just too funny. Oh man. Because he literally said, I cracked the case, because if you know Scott, he's just hilarious, you know, and he was just like, that's it. That's it. I cracked the case. She got the gun from Martha Jane. And then he has started using, what is the name of that app? I downloaded it because he keeps making songs on it. I don't ever have time to watch him anymore because I'm always on here with you guys, which I love. I'm not complaining. I love. But like, you know, when there's not court, you know, like not trial, or they quit early for the day or something, I'll watch him because he court hops. I don't really like the court hop, but I like, you know, his chat and him because he's hilarious. What is the name of that? It's an app that makes AI songs. I know I downloaded it, but now I can't find it. I think it starts with an S. Suno or something like that. I don't know what it's called. So he made a song called Martha Jane's Gun or something like that. It's hilarious. It is absolutely. Oh my word. It is so funny. I wonder if I can find our claims.
Now, first off, the indictment, Ms. Frank went over the indictment with you. So I'll just touch on it briefly. Count 1, malice murder. Count 2, felony murder. Count 3, aggravated assault. Count 4, concealing the death. And count making false doubt that, we're disingenuous if we don't just get up here and do. And Mr. Weaver is going to be coming up. With, he does not have a PowerPoint. He's got 2 books and about 10 pieces of paper, and he's going to be specifically addressing that with you. But what I will be doing in mine is walking you through what the actual physical evidence was in the case. And we're actually going to start by walking through the front door of the Ferris problem. How does the doubt of a fair-minded, impartial juror honestly seeking the truth? Ms. Franklin, Mr. Weaver's going to say it to you again, and Ms. Franklin was right. There is a stair step. I found that several years ago, and I have used it ever since, and I absolutely love it because it shows what reasonable doubt is. Because you're not finding this case and deciding this case based on reasonable doubt. It is beyond reasonable doubt. So it's a doubt that you can give a reason for. They have to go beyond that. They don't just get up to the reasonable doubt step and stop, because that's not guilty. They got to get up on that top step beyond that doubt. And it is a long burden. Look at all the stairs, no evidence until a reasonable suspicion, probable cause, preponderance, clear and convincing, reasonable doubt, and then finally beyond reasonable doubt. They have not come even close. In the middle of this trial, she called law enforcement and said that I have to tell y'all something. Melody stole a gun from me in 2019, and it was a .38. And when did she say that? After, and you'll have this back there with you, after she admitted to it, after you watched this man on YouTube commenting over Rusty's testimony. And the title of this video, Did I Just Crack the Case? Because that man said, and I asked her, that's where the gun came from. The next day, she is on the phone with Captain Hands telling the story about how Melody stole her .38. There is no evidence that she ever owned a .38.
All right, we need to slip at a commercial break. We'll get you back for more. We'll pick it up right where we left off. The defense could.
Didn't see any blood for anybody that was in and out of that house. Just like they want the money that they had affairs.
Defendant murdered and desecrated her own husband.
Dang it. I went back too far.
She might be 84 years old, but she came up with this lie as the only way that she came up with this. She wants to talk about, Ms. Rankins wants to talk about her picture is in the dictionary next to the word credibility. She has no credibility. She watched this whole trial. She knows everything. She knew to even say what color the gun was because she can go back and watch Scott's testimony. What does she do? Yet again, can't get the color right. She got the holster kind of right. You can't get the whole thing because you got to remember stuff when you're telling lies, and it's hard. And I'm sorry, when you want to show up in the middle of a murder trial and your excuse is nobody asked me, and it doesn't become important until 2-3 weeks in, that's the definition of no credibility. And especially when you can't even prove to me that she owned guns. And, you know, she's got an excuse for that too. Didn't like guns, she moved it all over the house, blah, blah, blah. Show me something. They got nothing. I'll go on for more, but I got hurt.
The views and opinions expressed in this podcast are simply that, opinions. All are presumed innocent until proven otherwise in a court of law.
I want to make sure that my children, my grandchildren, Do you have a statement?
I do. I've written this so that I can get the words.
Okay.
On July the 5th, 2018, 6 years, 5 months ago today, began the worst nightmare that I could have ever imagined. Not only my world, but my family's world was absolutely destroyed at the hands of one person. I have had 6+ years of being told not to talk. Don't say that. Take legal advice. I could walk out of this courtroom today and drop over dead. I want to make sure that my children, my grandchildren, and Gary's family, and to be honest, at this point in time, the entire world who has viewed this. I have waited for years to make this statement to everyone. I want the world to know who did this. I have always heard that the courtroom is the last place you're going to get the truth. And has that ever been proven to be the truth in this case? Not only did I not do this, I know who did. I know Scott killed his father. He took my husband, the father of Chris, Emily, and Amanda. He took Big Daddy from our grandchildren, Ella, Addison, Olivia, Jax, and James, 3 of them who never got to know Gary. Scott, this is unforgivable. Scott has spent an entire life of loving and protecting you, but this I refuse to cover for you. My mother, your mom, begged me to take the blame for this. She said after she talked to you, after Gary died, that she knew you had done it. Her exact words were, "You are his mother. You have to take blame for this." And I told her no, that I couldn't. I still have 3 other children, grandchildren, and this is not a stolen credit card, a check, or a diamond ring that you've pawned, all of which you have done. I saw you coming from that burn pile the morning of July the 5th in your truck. You told me that you were checking on the fire to make sure that it wasn't going to get the woods on fire. You were at that burn pile in your truck. And you told me that your dad had told you to clean up the extra wood that was by the barn. I told Hayes that I had seen Scott that morning coming from the burn pile. So Hayes, where's that recording? I want to know. You told me there was multiple recorders. You did, but you sat here in this courtroom and you told this court that you didn't tell anybody about recorders, but you did. Where is that recording in the interview? You, Scott, immediately started saying that there was a gun missing, a gun that nobody knew about. You never mentioned before. I asked you more days than not where your dad was, and this was the first time you ever had that response. There's a gun missing. You should have you did start immediately spinning your story. Cameron were there the night before. You got so angry. Now I know why. When I went to feed the baby goat the morning that
Your Honor, I'm going to object at this point. It's all about facts of the case. You, in fact, misstated. Her statement needs to not be about facts.
Right. Well, Ms. Ferris, really not supposed to go into the evidence of this phase of the case. And what I typically do is if defendant wants to go into the facts of the case, I'm going to allow the state to cross-examine or ask questions, which I don't really anticipate you want to do.
I would just ask to
But
close, Judge.
your statements needs to be constrained to the punishment, and, you know, if there's things you want to talk about in relation to that and how I should sentence you, I don't have a problem if you want to continue to profess your innocence, but we're not going to go on for a significant period of time. You resuscitate your view of the case and your opinion as to what the evidence is without your prior testimony and without the state being able to cross-examine it. It's not proper. So I'm going to ask you to restrain your remarks to comply with those directions.
Judge, this needs to be known.
Well,
I'll just ask to respond, Judge.
all right. All right, go ahead.
I went to feed a baby goat the morning of July the 5th before I left for the lake. I saw where you had washed out the barn. I later found that several bottles of house wash were missing after this all happened several weeks ago. Now I know why. The photos of your bathroom spotlessly clean. Now I know why. I know why you demanded me to move the tractor that you so were upset about it being in the place. Now I know why. Scott, you called me on July the 4th and asked me what my plans were for the day. And I told you I was going to the lake with Amanda, and you were so glad that I was going. I thought it odd then. Now I know why. I found copies of my birth certificate, your dad's birth certificate, our marriage license in your truck. Now I know why. Scott, I saw Gary going to that barn the night of July the 3rd, right after you got home. And then Scott is going, and I thought then Scott's going to be in trouble for staying at the lake and playing golf all the time. Never in a million years did I ever think that this nightmare was starting then. I told you, Detective Hayes, that I saw Scott going over there to the barn. Where is that in the recording? A bag. I know exactly where and when I was standing. Scott, you put antifreeze under my kitchen sink to set me up for this. That only you would have known where it was because it was for the Mercedes. When Amanda and I were putting that house back together, you sat in there and watched us like a hawk. Now I know why. You became so angry when the fire investigator came in July, weeks after this nightmare started. Now I know why you were so angry. Scott, you failed your polygraph test. You recorded meetings at the attorney's office and turned them over to the DA's office. We hired Manny to help us. Emily is the one who used her daddy's credit card to pay for that attorney. Scott, you got so angry that your sister Amanda was getting my personal clothes and my personal things to the point that Cherokee County had to be called. That is not the actions of the same person. Scott's anger issues have all been a huge issue. When he was in kindergarten and elementary school, Chris would.
I'm objecting. At this point, she's dragging Scott through the mud and his character. This is not.
All right, Ms. Ferris, I'm going to cut you off if you keep just wanting to resuscitate facts that aren't before the court. And Ms. Frankish, I'll give you a chance to respond to the extent that you want to and give you closing statement.
I am the mother that was always there for my children, even though they had done things that were wrong. Chris, who took care of your girls and loved them if they were my own, who came and got them off the street when you were acting an absolute fool because they were scared to death, who drove down to Buckhead and got your children.
Now I will tell you, okay, so just to kind of give you some direction. Things that are appropriate, you helping take care of your family, raise your family, those kind of things, what you've done throughout your life, and asking the court to exert some sort of mercy on you, things of that nature are appropriate. So you can talk about those kind of things, but let's don't go into the individual facts or things that haven't been previously presented to the court. Okay? All right, go ahead.
I love Ella and Addison more than life itself. And it was their life or mine, it would be mine in a heartbeat. Emily, who helped you move to and from an apartment and a house in 19-degree weather, even though I knew that you were trying to keep it from me. I was always there for you. I came back to you in Thompson Station after your husband was arrested to care for you and Olivia. I am so sorry that your children will never know their big daddy. Amanda and Chad, words cannot express my gratitude for everything that you've done for me. Thank you so very much. And I was fortunate enough to get to care for James every day since he was 3 weeks old. He is my pride and joy. Love for that little boy is unbelievable. I spent 18 plus months in the Cherokee County Jail over something that I did not do. The last thing, I thought that was the last thing I could do to Gary, for him, to get justice for him. I can remember thinking, it's okay that I sit here. I just want answers. That's all I want. And I still haven't gotten them. And I don't think that I ever will. And that scares me to death. Amanda was the only one of my children that got up here and told the truth. And I thank her for that every day. Judge Cannon, I had so many questions, so many whys. Why were so many things not their task? Why was the barn never checked? I think that would have given us so many answers. Why did they run out of Blue Star? They were on my property for days. I beg of you to get answers. Judge Cannon, I'm begging for justice for Gary, for my children, for my grandchildren, for Gary's family. And I am begging that you throw out this verdict. Be the 13th juror. Help us get justice. I did not do this. I promise you on my life, the 18 months that I did in Cherokee County was nothing compared to the last month that I spent in there. Now I know that Cherokee County did not do their job in the investigation. They took Scott's story and ran with it. I know that in my heart, body, and soul, who did this. And I'm begging for help. I'm begging you, Judge Cannon. Please do not send me to prison for something I didn't do. I did not do this. If I had done this, I would take this charge gladly. If it would bring Gary back, I would gladly go to prison. I do not want to wait years for an appeal. I've waited 6 years and 5 months for justice already, but here we are. Maybe I should have testified, but I listened to legal counsel. I wanted the truth out there, and this is why I am making this statement. I will talk to any and everyone who can help me and my family. I never wanted my family's life to be played out for the world to see. It is a mother's job to protect her children, and I cannot protect the person who did this. We can't replace Gary. That is unforgivable. I promise you to work hand in hand with the DA's office. But what scares me the most is that because of several individuals, so many others in this county that did not do their job, justice will never be done. For the last 6 years and 5 months, my every thought has been consumed with this. No matter what I do, it never leaves. And until you have lived this, nobody can understand. And I would not wish this on anybody. When I heard of the mother of the boy at the Appalachia school shooting, she called to tell that her own son was going to the school with a gun. My heart broke for her. This is a mother's worst nightmare. Judge Cannon, I beg of you for help. As one parent to another, help me get justice for Gary and my family. A mother, or at least not this mother, does not blame her child unless she knows he did it. Not thinks, knows. And I would never sit here and let the attorneys lay blame to him if I didn't know. You have no idea how heart-wrenching, gut-wrenching this is. John Luke says that I'm the most stoic person he's ever met. My response was, you never know how strong you are until that's your only choice. So before it's said that the only reason I'm telling you this is because I got a guilty verdict, it's not. If it had come back as not guilty, I would have still been begging for justice, for help getting the right person convicted. As soon as I walked out of the courtroom, I promise you I would have done that. Chris, Emily, Amanda, Ella, Addison, Olivia, Jack, and James, I am doing this for you. Gary is gone, and trust me, when I say that he is in a better place, because this has been the worst nightmare. It's been hell on earth. Knowing that your own son did this. And it's only been by the grace of God that I have survived this last 6 years and 5 months. If I could, I would gladly trade places with Gary. Judge Cannon, I am begging you for help. Please do this for Gary and my family. I have missed years with the people that I love dearly. Help me restore my family. Be the person in Cherokee County that it is their task. I do not want years. I do not want to wait years for justice, years that I may not have. I know this is something that you may never have seen before. And I plead with you to roll this verdict out. Help me get justice for the correct person. As bad as it sounds, I want to be there to watch him chained and shackled and brought to justice. I plead with you. This is something that I will never recover from. I don't know that my family will ever recover from. Please help me. I'm begging you to restore my faith in the judicial system. I'm begging you, not for me, but for Gary and my children and my grandchildren.
All right, Ms. Frankish, you want to respond to anything?
Very briefly, Judge. When the attorneys had the opportunity to give service,
Okay, can you hear me now? Can you hear me now? Am I back? Okay, good. It told me I saw that I was muted. You guys told me I was muted. I saw that I was muted. I unmuted, but it didn't unmute me, I guess. Yeah, who does that to their kid? What I said was I don't have biological kids, but I've heard women say, I would die for my kid. I would go to prison for my kid. Like, who does that? The boys and one of her daughters don't even speak to her anymore. I don't think they call her mom either. Just like in the Linda Sturmer case, they don't call her mom anymore. She's Melody. But they investigated Scott because she steered them to Scott. So they did but another reason they investigated him too was because there was a gun in the house that he had seen way before this, and he made it a point to tell investigators that he had seen a gun in the house before they even knew he'd been shot. Because he had been sick. He ended up with like this mysterious illness. They didn't know he'd been in the hospital. They didn't know what was wrong with him. I personally think he was diabetic and didn't know it because he was a big guy. I mean, he was probably overweight, but he was just a large man. Very, very stocky. But he drank Mountain Dew constantly. Mountain Dew and cigarettes. All the time. Mountain Dew and cigarettes. And I was like, well, you could have heart disease from the cigarettes because you get cardiac issues as well as lung issues with cigarettes. And Mountain Dew, all the sugar and caffeine in Mountain Dew all the time. He could be diabetic or he could have cardiac issues and not knowing it. So, but they would have found that in the hospital though. So, I don't know. But there was one time where he got really sick. They rushed him to the hospital and she called everybody like, your dad's dying. You need to come to the hospital now. And they got there and he was sitting in bed like fine. And then he went home the next day or a couple days later or whatever. So she made a big deal out of him dying and he wasn't. But the antifreeze thing she was talking about, they kept saying that they thought she was trying to poison him. And so then her story was, well, Scott put antifreeze underneath my kitchen sink to make it look like I was going to poison him. They didn't even sleep in the same bed anymore. They had one of those, like with the Linda Sturmer case, they had one of those walk-in basements. So it was like a split level house like that with the basement was all done up with like it had a sliding glass door that came right out of the back of the house. So he was in the basement and he lived in the basement. Had his office down there where he worked. I mean, he went to his law office too, but he had like an office at home where he worked. And then his living area was down there. And then the house was hers. He had his TV and he had a sitting room, and I guess he had to go upstairs to eat, like she fed him, whatever. But I don't remember how many acres, but huge property. It was very, very much like the Murdaugh case as far as home and property and that kind of a thing. And so the deal with Scott was he lived on their property. He had like an apartment above the barn, and he didn't really have a job. He supposedly his job was taking care of the farm or ranch or whatever they called it. I don't know if he got paid or I guess they had to pay him something because he had money like to go off and like he golfed with his friend, and from my understanding golf is not a cheap sport. So but I think that was like the big deal was that he just kind of gave Scott whatever he wanted, but then Scott would also, I guess, like use the business credit cards for personal stuff and took advantage of the fact that they gave him things, And then Scott had a reason to explain all that. So he took advantage of his parents, put it that way. But then the other kids did too. But when you grow up having parents that have money and give it to you like that's learned behavior. So then you can't turn around and blame the kids when you teach them that you can do that. You teach them that, oh, come to me and I'll bail you out when you're in trouble. Then you can't turn around and accuse them of taking advantage of you when you've always bailed them out when they get in trouble. And I can say that as someone that has the same experience, because my dad did the same thing with me. And I think that's why I'm so crappy with money now, because I always got bailed out whenever I needed it. I just, Daddy, I need money for this, I need money for that, and that's a learned behavior. So now I'm happy, but I'm broke all the time. But yeah, she's a piece of crap. Watch the 48 Hours. I believe it's called the Ferris Wheel. Watch that 48 Hours episode. This family is, man, oh man, this family. It was a good trial. It was absolutely a good trial. The boyfriend testified. Oh, and they had these weird code words when she was in jail. Code words. They'd say all. What was the other one, Judy? All. One was all. And the other one is. Not all. What does that mean? All. It wasn't doing anything. I just tried to turn off my camera to prevent it from doing something, and it decided it didn't want me to do that. I can't win with StreamYard. I just can't win.
All right, jurors, fairly and so if I get frustrated at lawyers about something, I try not to, and I don't think I can, but if I seem to cut somebody short, the lawyers are just doing it. When they request sidebar conferences, they're just doing it. I am going to try and keep all sidebar conferences to a minimum, but the lawyers are just doing it. Okay. All right, go ahead, Mr. Alessi, let's go to the witness.
What the heck was that? I get frustrated at the lawyers because they're just doing their. What the fudge was that speech, Bev?
Certainly.
Afternoon, Your Honor.
May I, Your Honor?
Yes.
Good afternoon, Ms. Hyde.
Good afternoon.
I notice you have some documents with you. Could you just state what is in front of you so I know that I might be able to help expedite this if I know what you have in front of you?
Absolutely. I have the first digital forensic analysis report I completed for the previous trial.
Do you have a date?
Um,
You have several of them.
I do. It's the first one. I apologize. This is the one, I believe it's May. I don't remember the
May
day
of
off the top of my head.
2023,
May of
perhaps?
2023, obviously. Then I have the second one. This was the one that was used in the pretrial motion.
December 2024?
December 20, yes, that's correct. Very nice. Then I have the third one. This is the final one regarding the phone that was identified as Ms. McCabe's.
Yes.
And then I have the fourth one, which is the phone of Mr. O'Keefe. And then I do have the opinion from State versus Huera, but if we don't need that, that's fine.
Okay, very well. I appreciate you telling me that. In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object.
You have to move along from this case, from what you're talking about. You have to move along from that Maryland case.
So with regard, do you recall another case from the state of Massachusetts, Arrington case, in which you submitted a pro se amicus? Do you recall that case?
I do.
And is it correct that in that case, you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position in that quote, friends of the court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct?
The statement is that frequent, I do not have that amicus in front of me. It has been a year and a half since I've read it. But that amicus does discuss frequent location history records. And I want to be clear, it speaks to both bias on both sides and negative and positive of submitting it. It was an unbiased writing, and it was not specifically in support of the prosecution.
So you are testifying in this case on behalf of the prosecution, correct?
In this case, I was hired by the prosecution.
Right.
That's correct.
And the prosecution is paying you for your services in this case. Is that correct?
Yes.
And with regard to this case, you have been paid and have been on this case since May of 2023, correct?
That is correct.
With regard to the various reports that you have submitted in this case, you have mentioned one, which is a report with regard to the iPhone of John O'Keefe. Is that correct?
That is correct.
And you have, in that report, you have made a statement, have you not, that from 12:20:50 a.m. on January 29th of 2022 and after, there is no indication of interaction with the device. Is that correct?
There is no indication of user interaction with the device. There is all received until about 6:04 a.m. when there is again Apple Health data that picks up.
I'll ask it again. And you can feel free to turn to page 1529 in that report.
Page 15?
Page 15, 1529.
The report is.
Would you like the
50
page of the
pages.
report or the page NDA number at the bottom? I can do either
Oh,
way.
I'm sorry. I thought you were saying page 15 in the report.
No. It's
I
NDAO
apologize.
1529 or page 7, whatever way is
Page
easy.
7. Okay, Roger.
Okay, so page 7, you see there's a heading interactive phone activity, correct?
Yes.
And at the top, it says, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20.
Yeah, you have to
Slow down. Okay, sorry about that. I'm just trying to move it along, but I will be slower. I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. You see that statement?
Yes.
And then if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct?
Can you answer that? Can you answer that, yes or no?
Did I read that correctly?
You read it correctly,
Thank
yes.
you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39. And it will be, thank you. And if we could go to slide 82, please. And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red, and this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us, he said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is, you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12:20:50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button on the side of the phone of Mr. O'Keefe a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
Is there anything that had prevented you from reviewing that in that data before you wrote this report?
Not that I can think of. I would have to go and re-review that.
My question is,
I don't know if that artifact, I have not reviewed that artifact, so I cannot speak to an artifact I have not reviewed, and I did not, that is not my report, that's Mr. Withenbert, so I cannot speak to that without going back and reviewing that evidence.
Isn't the interaction with the device, a lock button, readily available to you in the data that you have and had in your possession when you wrote this report?
Yes.
Thank you.
Oh, she mad. You missed something, girlfriend. You ain't smiling now.
If you could please turn to, in the same report, page 1528, which is your page number 6. And I just want you, please, to go to the, just put a placeholder in that. And if you can now just go to the conclusion, which is your page 50. Let me know when you're there.
I'm there.
So in the conclusion, you state that starting at 12:01 a.m. on January 29, 2022, the mobile phone was in use with activity of Waze navigating to 34 Fairview Drive, Canton, MA, audio playing text messages and calls until 12:31 a.m. EST on January 29, 2002. Did I read that correctly?
Yes.
That statement is also incorrect, isn't it?
On what basis?
Do you believe that statement is correct or incorrect?
I believe that the statement is correct regarding those artifacts that are mentioned in that statement, yes.
Okay, if you could please, if you could turn to page 1535 of the same report.
Can you give me my page number?
I will.
Thank you.
You're welcome. If you could turn to your page 13.
13, Roger. Yes, I'm there.
And do you see an entry that says 12:31:56, which is the same time in the conclusion, but I'm going to develop it.
I believe I know where you're going.
Hold on. I'm sorry. I need to ask the
apologize.
questions.
Yes.
I appreciate you looking to help, but if I could, I'd appreciate it.
Absolutely.
Thank you. So it's got health steps and it has steps 36, duration 20.9 or 20.398 seconds. Did I read that correctly?
That is absolutely correct.
So if you look at this data point in your report on page 13, the steps began at 12:31:56, but they ended 20.39 seconds later at 12:32:16. Is that correct?
That is correct.
So therefore, your statement in your conclusion, if you could go back to 50, and this is in your conclusion, your statement there is that the steps, the mobile phone is used with activity, including steps until 12:31 a.m. EST. That should read until 12:32:16, correct?
It depends on your interpretation of interaction. As a user is walking, they're not actively interacting with their device. It's their movement that is. It's not direct interaction with the screen. But I would agree to your view that could be interpreted as needing an additional 20 seconds.
Isn't the more correct way to state the conclusion that the active interaction when it comes to steps is not calibrating using the screen, but the phone is calculating steps taken. Isn't that correct?
That is correct, but that's not interactivity with the device.
I understand,
Yes.
but the sentence reads includes steps, and the more accurate way to have stated that would have been to put 12:32:16 instead of 12:31 a.m., correct?
I'm sorry, you just said 12:30. I did this to the minute, not to the second. Could you rephrase what you were stating?
Well, I'll state it again.
I appreciate that.
You're welcome. So isn't the more correct way to state this important data point in your conclusion, instead of saying active interaction with the screen and steps, etc., until 12:31 a.m. EST, the 12:31 should be 12:32 because the steps that you have on your page 13, by what you concede, is the duration of 20 would have brought it to 12:32:16, correct?
I would state that depends. I believe either is a correct way to state that. Based on interactivity, based on your interpretation, your definition is more correct.
Okay, thank you. And it's not my interpretation. I'm reading from your report, correct?
Your interpretation that 12:32 is a more correct representation of interaction is based on your theory that interaction concludes when the steps end. And I'm saying both would be acceptable.
Okay, so let's follow up on this.
Sure.
Isn't it correct that it isn't my theory when the steps ended?
Oh, it's
if I could just finish,
please.
Because if we talk over each other, the stenographers. Thank you. So, my theory, it's just the simple math from an entry you've made on page 13 that the steps began at 12:31:56. They ended 20.398 seconds after that, which just doing the simple math is 12:32:16. Did I do the math correctly?
That is correct.
Okay,
I'm not
thank you.
debating that.
Thank you very much. So now what I'd like to do is to go to page 1528 of your report.
Do you have my page number for that? I'm sorry.
Yes, and I appreciate that you go page number, so I center in on the lower one, then I'll go immediately to the one. So it's your page 6, Ms. Hahn.
Thank you.
You're welcome.
Two most polite people in the room.
Just let me know when you're there.
I'm there.
Driving me nuts.
To Apple Health Data Steps.
Pleasant.
And we've been talking about steps because they're important enough that you put them in a report, correct?
That is correct.
So let's go to an important data point, therefore, in your report, in the chart, which is the second entry, which is, as you've stated, 12:21:10 a.m. Do you see that?
I do.
And you note under the data that John O'Keefe's phone registered 80 steps at 12:21:10. Did I read that correctly?
You did read that correctly.
And those 80 steps constituted 191.253 seconds, as you state, correct?
That is what is stored in that database, correct?
And is my math correct, so that the jury understands this perhaps a little better?
Sure.
That 191.253 seconds equals 3.2 minutes?
Approximately, yes.
Approximately.
I'm doing the math in my head, so that's why I said approximately.
Right. Understood. So am I reading this entry correct, that you're stating what the data shows, that 80 steps were taken by the phone of whomever had the phone of Mr. O'Keefe? There were 80 steps taken at 12:21:10 a.m. on January 29, 2022, for a length of time of 3.2 minutes.
That is what the phone registered.
That's what the phone registered. Very well. Now what I'd like to do is to turn to the phone of Jennifer McCabe.
Okay.
And that is for your reports. You don't date your reports, so I give you a date, but it
I know,
says
it's report 3, I believe is what you're looking at.
exactly.
Yep.
It's 3. And there is, bear with me, I'm accommodating your page reference, and I'll have it soon for you. It is your page 7. And let me know when you are there.
I am there.
Are you aware of an issue regarding the time of an interactive phone activity on Jennifer McCabe's phone at 5:07 a.m.? Are you aware of that issue, and particularly a communication to a person named?
I would check my address page for
Absolutely.
that time. I do now call to someone labeled Coco at 5:07:21 a.m.
And you can tell that because in your report on page 11, you list a 5:07:21 a.m. call to a Coco as outgoing, correct?
Correct.
Have you discussed that call with any member of the Commonwealth?
No.
Is it 5:07 a.m. on January 29th of 2022, correct?
That is correct.
There is no duration listed for that call. And if you just follow my questions, if you can, yes or no, is that correct? There's no duration yet listed.
Correct.
So what I want to do is to also note that that omission is not the only omission of durations from this report, or I'll state it differently. Let me withdraw that. There is no population of the duration column for any call from 12:14:30 a.m. on January 29, 2022, all the way through this 5:07:21 call. And you don't start listing durations until 8:59:34 a.m. Is that correct?
Yes, and explainable. The artifact.
I understand
Yes,
Mr.
okay.
Brennan can
Sure.
handle those on his redirect.
Absolutely.
So there's not a population of duration of calls after numerous early calls and phone, as you call it, interactive phone activity. Nothing populated in this report until 8:59:34. That's correct?
Yes.
All righty. Now what I'd like to do is to turn to the 22740 artifact that was the subject of much discussion on direct. And I am going to refer to that as an artifact. Is that a parlance that is familiar to you?
Yes.
And if I refer to that as a timestamp also, is that a parlance that's familiar to you?
Absolutely.
So I can refer to 22740 as a timestamp, and you would find that parlance acceptable.
Yes.
Thank you. So I'm going to do that. Just to keep it simple, I'm going to refer to it as a timestamp. Now, you've been on this case working for the Commonwealth since May of 2023, correct?
May 4th, 2023. That is correct.
So you've been on this case for 2 years, correct?
Not actively the entire time.
But you started on this case in May 2023. You issued a report in May
Correct.
of 2023, correct?
Correct.
You issued a report in December of 2024, correct?
Correct, after being rehired in November.
Right. And you issued more reports in 2025, correct?
That is correct.
So all of that activity has been on this case, correct?
All on this case, that
And
is
that's
correct.
been all on behalf of the prosecution, correct?
That is correct.
None of that work has been done on behalf of the defense, correct?
That is correct.
So let us now go to the timestamp of 2/27/40. Your opinions on what is the meaning of that timestamp have varied from May of 2023 until today. Is that correct?
No, that is incorrect.
Let's cover that issue.
Sure.
Let's turn to your May 2023 report. Isn't it correct that the report and your findings were pursuant to a request from Detective Lieutenant Brian Tully?
Correct.
And how many interactions have you had with Lieutenant Detective Brian Tully on this case approximately?
I really don't know. I'd have to go look back at email and call logs.
Is it more than 5?
Yes.
Is it more than 10?
Yes.
Is it more than 20?
I don't know.
So somewhere between 10 and 20, would that be fair?
Again, I'd have to review my call logs. I'm not
But it
going to
was
test.
more than 10.
More than 10, I'm sure.
So the issue was your use of various forensic tools that revealed a timestamp, a 2:27:40 a.m. timestamp on January 29, 2022. Is that correct? Is that a fair characterization of an issue you looked at?
Correct.
To page 5 of that report. And I would ask that you go to the last paragraph that starts with, in the instance of the Google search, and let me know when you're there.
I'm there.
So it reads, in the instance of the Google search, house long to die in cold, that was recovered from the write-ahead log associated with the X browser state DB SQLite database with the timestamp of 2:27:40 a.m. was marked by Celebrite as having this.
There. Yes.
So you use the words that Google search, house long to die in cold, was associated with the timestamp of 2:27:40 a.m. Isn't that what your words are in this report?
In that database, they are associated. That is correct.
Right. And in terms of page 3, if you could go back, of your report, under relevant findings.
Mm-hmm.
It starts with, there were 2 searches of interest that took place on the iOS device, and we're talking about Jennifer McCabe's device, correct?
The device that was identified to me as Jennifer McCabe's. Yes.
That's identified to you as Jennifer McCabe. And it's what you talked about on direct examination as her device,
Absolutely,
right?
yes.
It's not a mystery as to whose it is. It's not like you don't know, right?
In direct, I also use the phrase identified to me as Jennifer McCabe's.
Right. But your conclusion is the device you've been working on and analyzing for 2 years is the device of Jennifer McCabe.
That is how it was identified to me.
Do you have a different conclusion as to whose device it is?
I always am very, very careful that I did not assess the ownership. That was information that was given to me, not information that I personally assessed.
So are you uncertain as to whether the device you've been working on for 2 years is the phone of Jennifer McCabe?
The device that I've been working on for 2 years is the device that was identified to me by the Massachusetts State Police, Detective Tolley, as belonging to Jennifer McCabe when I began working and received that device, as stated in the evidence analyzed section on this same page.
So let's go, and we're talking about, again, to get back to the center of gravity. We're talking about a timestamp of 2:27:40 a.m., correct?
That is correct.
And when you issued your first report in May of 2023, the timestamp you were looking at was 2:27:40 a.m., January 29, correct?
I was looking at multiple timestamps associated with the same two searches.
Right. So what I'd like to do, you said multiple timestamps. What times are in the multiple category?
What I was tasked to do was to look at the times, the search, the Google search history, I'm sorry, not Google search history, the Safari history, which includes Google searches, associated with those two search terms within that 12-hour period. That was the particular task, not the task of looking at the 227, just for clarity.
Right. And I appreciate that it wasn't that. My question, I thought I heard you on direct examination, which is why I repeated the question, what I thought I heard on direct, but I'll ask you the question.
Sure.
You looked at and talked about on direct two potential times for a Safari search, which includes Google, one of which was 2:27:40 and the other one was 6:23 a.m. Is that correct?
I analyzed the meaning of those two times.
And then 6:23, is that correct?
So you are only talking then about the one that we're also talking about 6:24 a.m.
Okay, so we
Eastern time for clarity, because some of these records are in UTC, some are in local.
Fair enough. So you've got 2:27:40, you've got 6:23, and you got 6:24 that you were looking at, correct?
There are other timestamps that exist in the realm of what I was looking at, but those ones, correct, are the ones that are relevant in this report.
Exactly. And that's what we're talking about.
Okay,
We're just talking about this report.
Yes.
And so if you look under relevant findings, at the very bottom paragraph, you say, second sentence, a Google search for how long to die cold at approximately 11:23 a.m. and then how long TIDIE in cold took place at 11:24.
That is in UTC. I apologize for not having the timestamp format there, but that is the UTC time. The UTC time equivalent in Eastern Local Time would be 6:23 and 6:24.
So to be clear, in your report, you wrote 11:23 a.m. and 11:24, and you didn't put UTC next
Correct.
to it, did
They
you?
should. You are correct. That should say UTC. That is a typo.
And there's a significant difference between 11:23 and 2:27:40, correct?
11:23 is UTC, so its equivalent in Eastern Time would be 6:23. The artifact of 2:27 is already in local time, so that is in Eastern Time. So what we would be comparing is 2:27 and 6:23 and 6:24 to be appropriate. They're taking into account the data storage and which ones are in UTC and which ones are in local time.
I understand your explanation now.
Perfect.
But in this report, there is no UTC time down. You have two additional times in addition to the two times, two different numbers added to the two, correct?
The UTC was a typo. It should say UTC next to those. And the chart shows all of those artifacts in EST and is clearly labeled that they're all in EST.
So you would agree that it's better stated to state it a different way than you have in your report?
I would say that both are equivalent. I should have had UTC there. But yes, it's easier for the audience to speak in EST. I would say forensics examiners typically communicate in UTC, but we translate for our reports. And I should have either communicated that in EST or included UTC. I will definitely contend that.
So in terms of your May 2023 report, your first report in this matter.
Yes.
You on page 5, in the sentence underneath the block paragraph state, in the instance of the Google search, house long to die in cold that was recovered from the write-ahead log associated with.
That's correct.
The X browser stage with a timestamp of 2027:40 a.m. was marked by Celebrite as having this timestamp and being deleted. Did I read that correctly?
You read that correctly.
Now let's move ahead to page 7 of your report. Up at the top above conclusion. Importantly, at this time, you state, Testing shows great inconsistency with timestamps parsed from this file. It, however, definitive that the page exists in a tab.
Correct.
While a definitive reason as to why the timestamp is listing the time of 2:27:40 is unknown, the time is inconsistent with the timestamps associated with the same search. Did I read that correctly?
You did read it correctly.
So as of May 2023, you said the definitive reason as to why the timestamp is listed as 2:27:40 is unknown, correct? I'm just asking, is that what you wrote? Unknown.
I believe that the wording here is, sorry, I know I do use the word unknown. It says, while a definitive reason as to why the timestamp listing is the time of 02/27:40 is unknown. Sorry.
So you use the word unknown, your word in your report.
Yes.
Okay, so now what I'd like to do is to go on to
What is unknown?
the first proceeding in this matter. Do you remember giving testimony in a proceeding about a year ago under oath?
Yes, I do.
I am now going to go to that testimony, and if at any point you would like to have a copy of that, if it's the honor, if your honor would like, I will do it, but I'm going to start and then we'll see how it goes. So
I have a feeling she's going to remember. Seems like the type.
bear with me a moment. Do you recall in that testimony stating that you processed the image in several forensic tools? I use Celebrite Physical Analyzer, and then you list many other tools. Do you remember giving that testimony?
We have a page.
I'm sorry, Mr. Brennan, I thought I'd given it 1-12. My apologies if I didn't. It's June 14, 2024, page 1-12. You're welcome. So do you recall giving testimony about the various tools you use for this timestamp?
I do.
Okay, so hold up. She wrote in a report that it's unknown why the reason Hoslong to die showed up at 2:27, yet she's telling everybody it's because the tab wasn't closed? Well, that's ridiculous. Maybe it showed up because that's when she searched it.
And do you recall stating that those tools were commonly used digital forensic tools that are very standard?
I'd have to see the wording that I used at that exact time.
Would it be helpful to refresh your recollection if I showed you that?
It'd be great, would greatly appreciate that. I do not recall the precise wording. I know that I.
Fair.
Mr. Lessie, you offered a transcript. Do you have the whole
I have
transcript?
the whole transcript if that helps.
It might seem the wrong.
Agreed.
Okay.
We have one up provided. Ms. Hyde, I'm going to give you a transcript.
Thank you. I appreciate it.
So may I put you on?
Yes.
Thank you. Mr. Brennan. Transcript. 112. Thank you. You are. That's let me turn it over to. It's going to be 112. Okay. Yep. You're welcome.
Thank you so much. And you said we're on 112?
Yes, please.
113, I see it. I see it's highlighted on the copy, so I
Right,
figured
so
that's the
what I
one.
wanted to do, the reason I said 112 is that's where I
Oh,
started with my
sorry.
previous question. So I'm not going to repeat the question, but just to orient you, so you have a fair context for the questioning.
Fair.
So I started at the bottom, 112, now I'm moving to 113, and I'm starting with line 7. Do you see that?
I do.
And it says, yes, they are commonly used digital forensic tools that are very standard for other forensic examiners to use on mobile exploitation. Did I read that correctly?
That is correct.
And then if you go down to line 22, you testified in that proceeding. So it's important to use multiple tools so you can see the results from different data sets, and be able to compare those results and enhance those with manual analysis. Did I read that correctly?
You did, that's correct.
And then going up to page 114, line 5.
Slow down a little bit, Mr. Alessi.
I will, Your Honor, thank you. Yeah, that's very, very typical for me to process with multiple tools to ensure that I'm getting the most complete interpretation from forensic tools. Of course, you go beyond that with your analysis, but it's absolute. Did I read that correctly?
That is correct.
And then lastly, for this section at page 114, 17, the Sanderson tool is meant to look at specific type of data structures called the SQLite database. SQLite databases are very nuanced, and this particular tool allows you to take that database and explore it at a deeper level than the other forensic tools allow. Did I read that correctly?
Yes, you did.
Thank you. Now if we can go to page 124 of the very same testimony. And feel free to go back a page just so you can see to page 123 that the topic is the 2/27/40 timestamp associated with house long to die in cold. Do you
Can I
see-
have a moment just to review and get context?
Absolutely.
Thank you so much.
Page 123:13, but if you need to go back further, feel free.
Every time someone says, "Did I read that correctly?" I think back to Johnny Depp going, "Yes, you read that very, very well."
Okay, I'm good. Thank you.
You're welcome. So what I want to do is start with page 1-23, and this is your line 16.
Mm-hmm.
I have them in the timestamp order that is associated with the artifact. Use that word associated again. Did I read that correct?
Yes.
That's associated with the Google search house long to die in the cold in a 2:27:40 a.m. timestamp, correct?
That is correct.
Now, if you turn the page of the testimony, you state back then that on page 124, line 1, the browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that the tab moved. It could be lots of things. Did I read that correctly?
You did.
Not one thing. You said it could be lots of things, correct?
That is correct.
And then you go on in line 10 and you talk more, and then you go down to the bottom. You go down to line 20 and you testified, we cannot tell by this particular artifact what time that search occurred. Did
Absolutely.
I read that correctly?
It's specifically pertaining to that particular artifact that in browser state DB that does not tell us what time a search occurred. That is correct.
Right. So you stated, and it was your statement then, we cannot tell by this particular artifact what time that search occurred, correct?
That particular artifact.
Okay, so now let's keep going.
Mm-hmm.
Fred Brennan isn't objecting. Your Honor, this is back from the case.
If you go to page 129 of this transcript.
Oh yeah, she's ticked
I'm
off.
there.
At the top,
Sure.
line 1, 227 isn't necessarily one time when the tab was closed. That's in my report. I say it's undetermined. Remember, we were just reading your undetermined
Absolutely.
in your May 23 report?
Correct.
Because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized. The next sentence. I don't know exactly what caused the tab to get that particular entry, but it's not, that timestamp is not indicative of the time of the search or any URL that's visited. But the first part of it is, I don't know exactly what caused the tab to get that particular entry. Did I read that correctly?
You read 100% correctly.
Thank you. Now, if we could turn to page 130 of your testimony.
I need to object.
Right, I'll see you both.
You don't have to put hate in quotation marks. You can hate things. I mean, if you want to hate people, go ahead. I have a bad habit of saying, oh, I hate that person when it's not the person. Like, Brennan could be a perfectly the way he's doing this case. I hate the fact that he even took this job. You know, like, and Beverly could be a perfectly nice person for all I know. I don't think she should have been the judge on this case. And I don't like saying hate when I don't mean hate. Hate is something reserved for people that really, really do something awful, terrible, horrible to you. I don't know these people, so I don't feel like it's my place to say I hate them or not. But what did you say? Strongly dislike, heartily dislike. I like that. I'm gonna start using that. Heartily dislike. Oh, I'm sure he doesn't know. I'm surprised he asked the questions he did. Because I got lost on direct. I'm following cross better than I did direct. Yeah, that's true. Lally probably would have done a better job. See, I'm confused because I don't use Safari when I Google. I don't even have. I deleted Safari off of my iPhone. I have like a Google app I go to when I Google things. So when they talk about Safari and tabs with a Google search, I have no reference to understand that. I don't know if it goes to a web browser or what. Because I just use the Google app. Maybe it opens Chrome. I don't know. I don't know if she's being condescending. Maybe she is, because she got mad a while ago. Like, I totally watched her demeanor change. So maybe she is being condescending, but she's also used to teaching. And teachers tend to speak condescending. because they're speaking down to people that don't understand, you know. But they're also both being uber polite to one another, which is driving me nuts.
Thank you for your patience, Ms. Hyde.
Absolutely, sir.
What I'd like to do is to go back to your testimony in the first proceeding, and we can go back to page 1-30.
I am there.
Thank you. So I am going to go back just because there's been some time and give some context. So we're talking about the 2:27:40 a.m. timestamp, correct, at this page location?
We've been talking about that for several pages. Yes, that's correct.
You're absolutely correct. We've been talking about it for several pages. And bear with me, I think this
No
may
problem.
be either the second to last or the last. So there you testified with regard, this was when you're referring to an artifact. You've agreed that timestamp is a fair synonym. You say on line 5, that means it wasn't in the regular database, it was in the write-ahead log. And to Celebrite's credit, that tool actually parsed the write-ahead log and displayed it where the not. So am I correct that here what you're stating is Celebrite was actually showing the 2:27:40 a.m. timestamp at that time during your testimony in the first
On
proceeding?
that date, that is correct.
Okay,
Yes.
so I just wanted to establish that, and you were giving
Absolutely.
Celebrite credit for actually showing that timestamp at that time of 2:27:40 at the time of your testimony back in June of 2024, correct?
That is correct.
Okay, so now let's go to page 1-36.
136, you said?
136, yes.
Thank you.
And on line 12, you note that so Celebrite and Magnet Axiom, and then you elaborate, both Celebrite Physical Analyzer, which is a specific tool, right, of
Correct.
Celebrite, and Magnet Axiom, another specific tool, correct?
Correct.
Both have file system viewers that then have SQLite database viewers. And you, skipping down to line 17, you talk about they don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite, correct? I read
That
that
is
correct?
correct.
So is it fair to say that what you did up to this point in June of 2024, with regard to the 2:27:40 a.m. timestamp on January 29, 2022, you applied a variety of tools to analyze the issue of when did the Google search occur, that you use the words associated with a Safari Google search, house long to die in the cold.
There's a little bit of wording I would correct there if that's okay.
Right, but so let me see if I can ask the question
That'd be great.
a different, more simple way.
Thank you.
You're welcome. So you used a variety of tools to analyze that house long to die in the cold search, correct?
Plus manual analysis and testing, yes.
Plus manual analysis and testing. Alrighty, now let's leave the testimony.
Okay.
And let's go to your next report. And your next report is December 2024. Do I have
it correct.
chronology correct, Ms.
That
Hyde?
is correct.
So in December of 2024, just approximately 6 months ago, you issued another report, correct?
That is correct.
And you got the request for that report also from the Norfolk District Attorneys, correct?
That is correct.
And you state in regard, well, that report regarded the analysis of the same timestamp, correct?
Correct.
To 2:27:40 timestamp. And in that report, under relevant findings, you state, and this is December of 2024, so
Mhm.
it's from your May 2023 report, it's approximately a year and a year and a half. Is that approximately from your May 23rd report?
Approximately.
Approximately a year and a half?
Yes.
So a year and a half after what we just reviewed in your May 23rd report, and then just months after the testimony of June, right? So about 6 months after your
6 months later.
June testimony that we just went through, you went and looked at this issue again, correct?
That is correct.
And isn't it correct that when you were asked to look at the same timestamp in December of 2024, that Celebrite removed the timestamp from their tools?
Celebrite did remove that timestamp from the tool. That is correct.
Okay. And that timestamp was the subject of extensive reports and testimony that you participated in the first proceeding, correct?
That is correct.
And even though that timestamp, 2:27:40 a.m., that showed up in Celebrite Tools, Magnet Forensic Axiom showed up, that was removed by Celebrate, correct?
Celebrite no longer reports it. The evidence is still in the data. I want to be clear, just that it doesn't change the data. They just removed it from their automated parsing and reporting.
Right, so they
Correct.
removed it from their automated parsing and reporting, correct?
Yes, they did. That is correct.
However, your former company, Magnet Forensic Axiom, still shows it. Yeah.
Magnet Axiom Forensics currently shows it as a carved artifact and still shows that and gives a description in their artifact reference guide as to what they believe causes that artifact.
I'm going to ask the question.
Yes, it does.
Magnet Axiom Forensics, where you used to be the director of forensics,
That is correct.
still shows that timestamp,
Yes,
right?
yes,
But Celebrite doesn't in the
that
automated
is correct.
tools.
That is correct in their automated parsing.
And you would agree that Magnet Forensics is a very reputable company, correct?
Correct.
Quit talking when he talks.
Let's go back to your December 2024 report. Do you recall just moments ago when we went through your testimony in June of 2024 in the first proceeding, where you stated various times how it was, I'll use the term best practices, to use multiple tools to analyze the timestamp?
Correct.
And you used many tools back then to analyze that timestamp. And you testified to those many tools on your direct examination, correct?
Correct, yes.
However, in December of 2024, when you returned to analyze the 2:27:40 timestamp, how many tools did you use to analyze that timestamp? Can you give me just a number? How many tools?
At least 4.
Well, in your report, let's go to your report, what your report says.
Mm-hmm.
So source codes that are closed sources. So I just refer to them as Apple's closed sources. Wouldn't the best information about when a search occurred, what it's associated with, wouldn't the best information be in the Apple source code to answer that question?
It is acceptable in digital forensic science and in accordance with the NIST Science Foundation papers to conduct testing to determine how the functionality of something works. You do not need access to the source code to be able to speak to an artifact.
My question isn't that. My question is, isn't the best place, the best place to go is to the Apple source codes themselves, or are you saying these physical analyzer tools are just as
Those are very, those are incongruent statements. Apple's source code is not a healthy way to do an examination because it would be so onerous, and we do not know the level of documentation, we don't know the language. That is not necessarily the most effective way to determine what data is. Forensics tools parse results of how data is. They don't interpret them. The examiner interprets them and provides meaning. And I would like to state that those three things should not be conflated. They are very individual concepts.
I think you misunderstood my question.
I probably did it because that's what I was seeing.
My question is this. Isn't the best source for information about data in an iPhone contained within Apple source codes?
Not necessarily, because that doesn't perform. Operational performance is a better source in a practical sense to being able to determine what something is, as opposed to zillions, and no, I don't know the number because it's closed source, lines of code that may or may not have different levels of documentation. Apple themselves wouldn't be able to, any individual there who has access wouldn't know every feature of how every element works. Testing through the methodologies described in NIST is the accepted methodology in our science, not reviewing the source code.
I'm going to try it a different way. I understand what you're saying is, if I got it correct, you correct me. Are you saying that these physical tools make it easier to interpret and view the data?
I did not speak about the tools at all in the statement I just made.
Okay.
I spoke about manual testing and checking the functionality and what results. Parse tools, again, these are three separate concepts. The concept of code and actually reviewing code to make a determination is different from parse tool results, is different from doing testing and validation. Those are separate concepts. They should not be commingled as if they equate to each other.
So have you ever learned of, have you ever spoken with Mr. Whiffen? Ian Whiffen?
I have spoken with Mr. Whiffen historically, but not since the term of this trial.
Okay. Have you ever spoken to Mr. Whiffen about whether the Apple source codes are the best source of information about topics like timestamps? Have you ever spoken? That's just
I have not had that conversation with Mr. Whiffen, no.
Okay, all right.
Still.
I want to move on to, and do you regard Mr. Whiffen as a reputable?
Mr. Whiffen is a reputable forensics examiner, and I've actually reviewed his work in other instances and peer-reviewed his papers.
So you have regard for his reputation?
I have regard for his reputation.
Sorry, we have to wait for each other.
Oh,
to
yes,
talk
I'm
through the
sorry.
trend. It's all right, no worries. So you have regard for the opinions of Mr. Whiffen generally, correct?
Absolutely, yes.
And you believe he has a solid reputation, correct?
Absolutely, that is correct.
Now let's turn to the History DB database. You are familiar with History DB? History DB, are you familiar with that phrase?
I am familiar with that phrase.
Okay. Do any of the house-long searches appear in the History DB?
In this instance, no, we do not have artifacts in the History DB of either of those two searches.
So I want to just repeat that in a different way. So the History DB, is that considered a valid and valuable source of information in an iPhone?
That is a valuable artifact for Safari history. That is correct.
But the house-long searches we've been discussing do not appear in that History DB, do they?
That is correct.
You spoke about PYF PDF on your direct testimony. Do you recall that?
I do. It's the Python framework for PDF. It is a GitHub tool, a tool one can download from GitHub to utilize to create PDFs using Python code. So a developer and a tool would integrate that to create a PDF.
And the PYF PDF can have the variables set, correct?
Yes, the Python script allows the developer to set things such as their name that they created the document. Yes.
I want to go to the extraction of Jen McCabe's phone that you talked about on direct examination. Is that the hash value signed or unsigned?
A hash value isn't signed. I believe your question you're asking me is if the Adobe document that contained the PDF that contained the hash values, are you asking me if that's signed? Because a hash value is something that matches. A hash value isn't signed.
Let me ask it this way. Is there any hash value associated with Jen McCabe's phone that is unsigned?
That is not a valid question. I apologize. We don't refer to hash values as being signed or unsigned. We would refer to the PDF that contains that value as being signed or unsigned.
Have you ever read a report of Mr. Ian Whiffen in this case?
I have, but I have to be clear, I have not read all of Ian's reports. I've only read some, so I don't know if I read some of his earlier reports.
Do you recall reading a report of Mr. Whiffen where he references a hash value being unsigned associated with the iPhone of Jennifer McCabe?
Can I see said report so I can validate if I did or did not? I'm not sure based on just that, because I wouldn't use the term hash value being signed. I did see a report in which Mr. Whiffen spoke to the PDF not being signed.
I just want to try to shortcut this and work off your last statement. You're now saying you do recall seeing a report of Mr. Whiffen where he said a PDF was unsigned?
I need to see, I do remember him referencing the PDF. I would need to see the report, especially since the characterization of hash value being unsigned is not a term of art that I am familiar with in our field.
Let me ask if you agree or disagree with this statement.
Ruh-roh.
This value can be used to compare with the original hash calculated at the time of extraction in order to validate the extraction data. However, this requires authentication of the original hash value, which is not possible with gray key extractions, as the PDF containing the extraction hash value is unsigned. Therefore, this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%. Do you agree or disagree with
His
that
statement there says the PDF is unsigned, not that the hash value is unsigned.
Right, but it's nonetheless unsigned, correct?
The PDF is not signed. That is a correct statement. Gray key PDFs that purport that value are not an Adobe signed document.
Do you know the history of the extraction of Jen McCabe's phone? It's a yes or no.
Can you provide more clarity? What do you mean? Do you mean from the time the image was made? Do you mean from the time the device was received? Because I don't know the information pertaining to the receipt of the device into evidence, and then I only have the documentation of the image forward. So I want to be clear about what period we're talking about.
It's an excellent point, and I am going to follow up with some questions.
Okay.
In an extraction, doesn't the extraction from a phone start with the raw data, raw image? You tell me, when someone brings a phone in, what's the first step that gets taken in order to do a full file extraction? What's the first step?
It depends. There's got to be steps with regard to network isolation. I need to know if the device is AFU or BFU at that point. So I don't have that information from this case, if that is the question. I get from the image forward.
So what I'd like to do, and this may be my last section of questioning, I'd like you to describe the ideal situation as to getting the most reliable data from an iPhone from the start. What's the most reliable way to do it?
I would say the most reliable way is following the recently released SWIG-DE Scientific Working Group on Digital Evidence document on best practices of evidence handling, preservation, and imaging. I may have that title slightly out of order, but it is
Fair
the
enough.
document released this January.
And tell me what that is.
Sure. In that, the first thing, from which point are we starting? Are we starting like extracting the data using a tool, or are we talking on scene, taking the device into evidence?
The latter.
Okay. So the first thing you're going to do is you're going to ensure that you are isolating the device. This is also going to depend on condition from the network. So typically this would be done with a Faraday enclosure in a best practice. However, there are alternative ways of isolating from the network, such as disabling all of the communication protocols, such as Wi-Fi, airplane mode, etc. The next step, once you've isolated, but prior to, you also want to make sure you're continuing battery stat. So if a device is on, you want to keep it powered on. If it's off, you want to keep it powered off. That's a general statement. So the best way to do that is to attach a battery charger. Just like when your battery runs low, you plug in a charger in the back of these battery packs. We do that with that before we put it in the Faraday bag. A Faraday bag is an enclosure that blocks signals from coming to the device. This is so a remote wipe command couldn't be sent, or so that more data isn't received to the phone, because phones are live and instantly obtaining data. So we're going to have it with a battery pack in the Faraday, presuming it was on. Again, I don't know the status of this device. The next steps are going to depend on what state that device is, and what make and model that device is, and what the current support for that device is. There are multiple types of extraction methods of phones. In the modern day on iOS, a full file system image, what we had on the devices in question in this case, is considered the gold standard because it has the most robust information. So at this point, the next question is what's the best image type? And that's going to depend on if we have a passcode or if we don't have a passcode.
If I could,
Please.
and I'm going to allow you to continue.
Yeah, please.
I want to break it down for the jury. So what I now want to do, you've stopped at a certain point, but you've talked about securing, what I would call securing the phone, right? And then making sure that there's no data swipes. You talked about airplane mode, Faraday bag, Faraday box, right? Do you know whether any of those protocols were followed for either the iPhone of Jen McCabe or John O'Keefe?
As I mentioned, I was not there for those processes. I don't have documentation of it. As mentioned, what started where my receipt of the device is from the image.
Exactly. So you don't know.
I can't testify to processes I did not or was not available or aware of.
Fair enough. But do you have a little bit of hint as to whether the phone of Mr. John O'Keefe was properly secured in airplane mode, a Faraday bag, or a Faraday box, based upon your own report of the iPhone of John McCabe? Can you determine that from page 5 of your report?
Obviously, there is data signals that are still being made and created. I believe that is what you're referring to. So the assumption is that I don't know at which point a Faraday bag is employed, but I also want to be clear, I don't know when, I don't have information outside of the digital forensics realm about this case, so I don't know precisely when the phone was taken into custody by law enforcement.
Fair enough. So assume that Mr. O'Keefe was deceased around the latest 9 a.m. on January 29th, 2022. Isn't there activity on that phone, health data activity, up to around noon of January 29th?
Health data activity would continue to be reported regardless of if the device was isolated from the network or not. Health data has to do with the movement of the device. So if the device was being moved even within a Faraday bag, that data would still be populated.
How about location data?
Location data is unlikely to be reported in a device that is Faraday enclosed, but I do not know what location data you're referring to, so I cannot speak in absolutes without having a better reference to the artifacts in question. If you're saying it's in my report, I'll look at it. But again, I never knew when the phone was seized, so it was not part of my initial analysis. Do I have permission to look at that time, Nick? Yes. Thank you, Your Honor. So bear with me. It's a big report, as you know.
It is a big report.
And it was at the bottom of my stack.
Pardon me?
All right. It was at the bottom of my stack. I had to lift up the other ones to find it. All right. So,
Your Honor, may I assist in pointing her to a page?
Sure. That'd be
Thank
great.
you. If you could turn to that report on your page 47 and continue on to page 50.
I do see incoming data that is consistent with the device not being Faradayed, such as the receipt of SMS messages, notifications from Ring, etc.
So, the iPhone of Mr. O'Keefe was not secured in the manner you described before we got to this, as would be the best practice with regard to getting the most accurate data from a phone. That is, once it comes in, that it's to either be put in airplane mode, Faraday bag, or Faraday box. That's correct. By your own report, you see activity.
I do see activity. It was not Faradayed. Faraday prevents wiping of the device and additional data. So we actually, in this instance, it doesn't appear that the device was at risk of wipe because it was not wiped. And we actually have more data because we get to see the data that continue to come into the device. I'm not saying that's in accordance with best practice. I'm saying that that's what I see based off of what you just had me review in the data.
It sounds like you're trying to justify.
Oh, I'm not
if
trying to
right or
justify.
wrong, you tell me. It sounds like you're trying to justify the fact it wasn't secured. Am I correct?
No, you're incorrect. I'm just stating we have, you asked if we had more data or less data. We actually have more data with it not being Faradayed, but no, best practice would be to Faraday.
That
I
wasn't my
100%
question.
agree.
My question wasn't, is there more or less data? My question was simply, doesn't your own report show activity up until noon on January 29, 2022?
Correct. And for clarity, my scope was till noon, so I don't know if there was activity beyond that.
Right, but as far as your scope goes, I want to be clear.
Yep.
There is activity on
Absolutely.
this phone.
Absolutely.
Which shows that it was not put in airplane mode, it was not put in a Faraday bag, and it was not put in a Faraday box, and that failure is not best practice.
Correct. It is not in accordance with the best practices. I agree. I would have Faradayed it.
Thank you. So
if I,
that's
all
okay.
things.
I have no further questions. Thank you for answering my questions, Ms. Hyde.
Thank you for your questions. Have a great day.
Redirect.
Thank you. Of course.
Whenever you're ready.
Thank you, Mr. President.
You're welcome. You were asked when you began working on analyzing phones in this case, and you said it was in May. Was that of May of 2023?
May of 2023. May 4th, 2023 is the email I have of a note. Thank you. Yes. It's easy to remember because May the 4th be with you.
When you first were asked to begin work on this case in May of 2023, what was the catalyst for you to begin working on this?
Jeez.
I was contacted by Mr. Tully and then contracted, a SOW was signed, and I began work on the initial request to look at those two search terms on January 29th. Does that answer your question?
Sure.
Okay.
Was there a certain claim that was lodged that you were to focus on?
I was to focus on the two search terms from January 29th, 2022.
And were you informed why? Was there any context to that?
Probably, I don't recall the exact conversation that I had with the DA's office and Lieutenant Tully at that time, but I'm assuming that I was given that context. I have in my notes that I was to look at those 2 searches on that date and do an analysis about those.
Were you asked to reach any particular result?
No, I was asked to provide my report, not to reach a particular result.
Were you asked to reach a conclusion that the 227 timestamp was inaccurate?
No.
When you engaged in your analysis, was it independent of the district attorney's office?
My analysis was independent of the district attorney's office. I actually, in the first case, had very little communication with the district attorney's office during the period of my analysis.
Was there any input from any outside source on what your result or ultimate opinions would be?
No.
Would you ever allow anybody to affect your input?
No.
Throughout the course of your efforts with this phone, have there been changes to software?
Absolutely. As mentioned on direct, software updates are near monthly.
I want to ask you about changes to the Celebrite software. You were asked about certain reports you wrote. Were the reports that you wrote relative to different requests for analysis?
Yes.
The report regarding report number 3, regarding changes to Celebrite software, was that report limited to the timestamp change, or was it to include other efforts?
The scope of that report, may I review what I have documented as the
Please.
scope? I believe we're talking about report 2. That's the one about the Celebrate change.
Yes.
And I have the request was to understand changes made in the newer version of Celebrate Physical Analyzer to artifacts pertaining to the timeline of a particular Google search on January 29, 2022, namely how's long to die in cold.
When you looked at the Celebrite software and report, was the timestamp characterization changed or removed?
Yes, it was removed. That timestamp in the version starting in May of 2024, Celebrate actually removed that, and they put a release note stating that it was due to the ambiguity and potential for misconstruing the meaning of that data.
Was there any other releases informing other reasons why that was changed other than the potential that somebody could misconstrue, misinterpret, or distort the information?
Can I read Celebrate's own statement?
Please.
Celebrate's statement in...
To yourself.
To myself? Okay, roger that. Thank you. I appreciate that. Can you repeat the
share with
question?
us, was there any reason other than the concern about misinterpreting or distorting?
They said that
So what's your understanding?
my understanding is that it is not a reliable timestamp, and that is why Celebrate removed it.
You were asked about Axiom. Axiom, is it the same or different?
Magnet Axiom and Celebrate Physical Analyzer are 2 different tools that both do forensic analysis of mobile phones.
You were asked whether Axiom still has a timestamp that was similar to Celebrate before the change.
Axiom shows what I spoke to on direct, where they have it as a parsed versus carved result. And so that particular result shows in the suspended StateDB artifact as carved.
Do companies like Axiom and Celebrite give releases, updates, information about how to interpret their reports?
So Axiom actually has a document that's released with it called the Artifact Reference Guide. And that actually gives a brief description of the fields and of artifacts. All tools, when they release new artifacts, they put out in a release note. Not all artifacts are clearly documented that are parsed. However, all of the vendors regularly put out webinars and blog posts that explain their new artifacts, but not necessarily all.
Is there any releases or cautions from Axiom on the same issue? issue about misinterpreting a timestamp?
Axiom in their artifact reference guide for this artifact does speak to the possibility of misinterpretation and states timestamp can be earlier than the search had occurred based on what different reason could cause the timestamp.
Let me ask you about a Faraday bag. You said that best practices is to isolate an item in a Faraday bag.
That's correct.
Do you have any information, or did you know the travel of Mr. O'Keefe's phone that night or where it went after?
I'm sorry, can you clarify the time period?
On January 29, 2022, from say 6:04 in the morning until later that afternoon.
I did not have access to that information.
When you analyze data from certain devices, are they always placed in a Faraday bag immediately after an incident?
There's a lot of times when this is situation dependent. An example of when you would not put something in a Faraday bag is when you have a deceased victim and you're going to be using their biometrics to possibly unlock the device. Because a Faraday bag is enclosed and then can't be opened, if your intent, if you don't have the password, is to use a deceased person's fingerprint to unlock the phone, we don't want to put the person's finger in the Faraday bag. So usually those phones would not be Faradayed, but they would typically have airplane mode enabled or SIM card removed. But no, SIM card removed doesn't actually work on iOS, so I won't get into that.
Understanding or having the opinion that this item was not placed in a Faraday bag at 6:04 in the morning, does that in any way affect your opinions about the data that you analyzed on this phone and the conclusions that you reached regarding Mr. O'Keefe's phone?
It does not have any impact on the conclusions other than the fact that it wasn't Faradayed and more data came in. So we have additional data.
You were asked a very specific question about History DB, and it was simply whether or not How's Long to Die in Cold, whether it appeared in History DB. That isolated question, does that provide any context for you and your analysis and conclusions about How Long to Die in Cold and that it occurred at 6:23 and 6:24 the next morning?
The absence of the History DB artifact doesn't mean that that search didn't occur at that time. We have multiple corroborating artifacts, which is usually what we look for, 2 artifacts that demonstrate is like very good. You don't necessarily need that, but in this instance, we have both from the Mobile Safari PLIS, which tracks the history, as well as the Knowledge CDB. So we do have 2 artifacts showing that those searches were done at that time. Of course, 6 seconds apart for the difference between the Knowledge C and the Mobile Safari PLIS.
On direct examination, you were not asked questions about Mr. O'Keefe's phone.
That is correct.
You were on cross-examination, so let me follow up. You have a report that you authored regarding Mr. O'Keefe's phone,
That is correct.
and you had an opportunity to look at the healthcare data for January 29, 2022.
That is correct.
Page 6 of your report.
Thank you.
You noted that there were steps that began at 12:11:09 a.m. Is that accurate?
That is accurate.
And the way healthcare data works, do you have an understanding whether steps means a person actually took a number of steps, or does it mean something else?
Steps doesn't necessarily mean that you took a number of steps. It's based on the motion of the device. So it could be steps. It could be you're carrying it. It could be that you're in some other kind of motion. You could be on a bicycle. You could, any number of things. And the number of steps.
It's been 84 years.
Is based on the presumed gait, based on the input into the Apple Health app in terms of gender and height. So it determines a gait and then prescribes a number of steps, but it is possible for other things to cause steps to occur.
You were asked specifically if you saw that there were reported movement or health steps at 12:21:10 a.m. and specifically pointed out to you notation or characterization of 80 steps. Is that accurate?
That is what's stored in the database. I try to clarify, as I did for you, sir, that that's what's stored in the database. I'm not saying that 80 steps were taken.
And by the way, in addition to the healthcare analysis, you did some analysis on the movement of a car, didn't you?
For Ms.
I'm going, I'm going to deny that question.
Can these health steps occur if somebody's holding a phone while traveling in a car?
As mentioned in my report, it's caused by motion. It could be various motions that could cause it. You could be using an elliptical, you could be in a vehicle, you could be on a bicycle. It's not necessarily steps taken.
Based on your analysis of Mr. O'Keefe's phone and the report that was pointed out to you in cross-examination, and do you have information or opinion where Mr. O'Keefe's phone was located around 12/21/10 while those steps registered?
Objection, Your Honor. So,
She was like that last time too. She got
It was pointed out to you at 12/21/10 there was a
untrivy for the first time.
registered 80 steps. Is that accurate?
That is correct.
Okay. And then you were also asked about the last healthcare data, the last movements of this phone. And it was pointed out that that began at 12/31/56 for 20 seconds.
That's correct.
I think he's saying healthcare.
Per the data in the database.
To piss off a less.
And is that the last movement of Mr. O'Keefe's phone that evening before 6:04 that you saw when you analyzed the entire data in the phone?
May I have one moment to review?
Yes. Because with Whiffen on cross, Alessi said it's healthcare data, correct? It's not called, it's health data, correct? It's not called healthcare data.
That appears to be the last before the 6 a.m. hour.
So that 20 seconds, if it began at 12/31/56, what was the last movement in seconds in time at that time of Mr. O'Keefe's phone?
I'm sorry, can you repeat?
Yes, if that was a 20-second interval at 12/31/56, what was the last second that evening that Mr. O'Keefe's phone moved?
12:32:16.
And then when you analyze the phone and were asked about these times, is there any movement between that last movement and 6:04:01?
Between the 12:32?
Yes, 12:32:16 and 6:04:01. Any movement of that phone whatsoever?
I do not have anything supporting that in my report.
Do you know what was going on with Mr. O'Keefe's phone at 6:04:01 a.m. on the morning of January 29, 2022?
I do not know precisely what was happening with his phone at that time in terms of movement. If that's, or are you asking me? I'm sorry. Can you clarify what you mean
Yes.
by the question?
The next movement after 12:32
Is the 6:04?
6:04:01
Correct.
a.m.
Correct.
Do you have any information about where or why there was movement of the phone at that time?
I don't. That wouldn't be inside my digital evidence, I don't believe.
And the last question is the next movement at 6:15:14. Do you know if that phone was being moved by somebody or somebody else than Mr.
The
O'Keefe?
phone was in motion. I do not know if it could be by a person. It could be on a rail car. I don't think it was on a rail car for clarity, but I don't know what is causing that motion at that time.
Thank you very much.
yes, please, Your Honor.
Did it be people carrying his body while it was in his pocket?
We have a moment here. Ms. Hyde, you were asked questions by Mr. Brennan just moments ago about Celebrite and release notes. Do you recall those questions?
Yes.
And did Celebrite, beyond stating that their opinion was the 2:20:40 a.m. timestamp was not reliable. Did they give any reason at all for why they concluded it was not reliable in that? I'm sorry, we'll wait for the,
Thank you, I appreciate it.
and I'll repeat the question.
Thank you.
have to thank people for every little thing. Shit. Drives me crazy. And they're polite when they're ridiculously polite.
May I, Your Honor? Thank you. In that release note, does Celebrite state any reason for why they wrote not a reliable timestamp?
There are other
I'm sorry, my
published, but
question
not
is, do they
Celebrite?
state in the release note whether there's a reason for why they concluded?
Thank you, ma'am. Thank you, Your Honor.
Please try not to talk.
I will,
Sorry, Your Honor.
Thank you.
2.
Asking you to read it, just asking whether or not they reliable timestamp.
One moment, I'd like to review what they wrote. Thank
Absolutely.
you.
You're welcome.
Yes, they do. They state that further research since is the reason that they're doing it, that there is further research.
Did they state what that research is?
They don't, but
All right, but they don't state what the further research is.
that is correct. They
All right,
state
now
that
what I'd like
it's
to do is
unreliable.
move on to Axiom.
Mhm.
You were asked questions by Attorney Brennan, and you referred to Axiom as using a different parlance with the timestamp of carved, correct?
Celebrite uses this deleted demarcation or recovered demarcation. Axiom does not do that at all. They speak to how they recovered the artifact, be it that it was parsed. When I say parsed, I mean the item was where it was expected to be in the algorithm, found it, located it, and said it's here, versus carved, which is when they have to go into an unexpected area, such as slack space, which would be the areas that are not yet used or were previously used to extract the data from that.
So Axiom actually recovers the timestamp, but Celebrite does not. Is that correct? Is that correct?
Yes,
Okay.
Celebrite, currently, previously, when we did the first case.
Right, but
It's the
currently,
opposite.
Celebrite
Correct.
doesn't, but Axiom does. Axiom recovers 2:27:40 a.m., correct? Timestamp? They
That
recover.
is the timestamp that they show for that artifact. correct?
Exactly. So now I'd like to go back to the next topic, our discussion about Mr. O'Keefe's phone and secured or not. You talked about one example of maybe needing to use a biometric to unlock a phone. And that might be a reason, as I understand it, as to why someone might not put it in a Faraday bag or box. Do I have that correct?
Correct.
Okay, do you know whether the passcode was immediately provided on the phone of Mr. O'Keefe?
I do not have that information.
Assume that the passcode was immediately provided for the phone of Mr. O'Keefe. Can you think of any other reason why that phone wouldn't be put in airplane mode, Faraday bag, or Faraday box?
Best practice would be to put it in a Faraday bag.
Okay. And that phone was obviously not put in airplane mode, Faraday box, or Faraday bag after 6:04 a.m. on January 29, 2022, correct?
Correct.
Now let's go to,
Well, I don't know if at some point past 12 o'clock. My report only goes to noon, so just for clarity, I don't know
Fair enough.
anything past noon.
fair enough, but from 6:04 a.m. until approximately noon on
Correct.
January 29, 2022. At least that time, that phone is not in airplane mode in a Faraday bag or Faraday box, correct?
It would appear such. Because I didn't analyze past that, I don't know if it had been potentially Faradayed and then it broke Faraday and got data, but I don't suspect that based on this. It appears that that data was live. But I just have to speak to the fact that I just don't know because I didn't go past noon.
Right, but you're going past noon.
Right.
I'm not.
Okay.
My
yeah.
question,
6
and
a.m. to
I'm-
noon, it does not appear to be Faraday.
So to be clear, from 6:04 a.m. on January 29, 2022 until at least noon of January 29, 2022, the iPhone of Mr. O'Keefe is not in airplane mode, it's not in a Faraday bag, and it's not a Faraday box, correct?
Unless it was in a broken Faraday bag, like they put it and it was failing. But it does not appear to have been placed in Faraday bag.
All right.
Well, I'm just being honest. You should test your Faraday bags. They go bad. I use Dr. Katz's testing methodology, but 100%, it appears to have been receiving signal for that entire period and not in a Faraday bag, which would be best practice unless biometrics were needed.
So let's now go to,
Can the interim leader be elected? I mean,
hopefully, what are the last two categories of questions? With regard to the iPhone of Jen McCabe, do you have any knowledge as to whether over 200 calls were auto-deleted on her phone? You analyzed it.
We can see that calls were auto-deleted. You're asking me if the number of, I just want to make sure I understand the question. If the number of calls that were auto-deleted, if that exceeded 200?
My question is, do you know whether there was auto deletions on Jen McCabe's phone? Do you know that?
I'm uncomfortable with the term auto deletions because I don't know what that is inferring.
Okay. Did you analyze her phone at all for deletions?
I analyzed her phone to see if there had been deletions of call logs. And what I found was that there were records that were removed by the system and not recoverable from that database, but were recoverable from biomes.
Understood. Now, what I'd like to do is to address your answer in response to Mr. Brennan's questions, where you said that the issue with regard to Mr. O'Keefe's, or just generally your proposition, that there was no impact on your conclusion because more data had been obtained. Did I get that correct?
I believe my statement was there was no impact on my conclusion with the fact that it had not been in a Faraday.
Right. So isn't it, though, the case that when a phone's not in a Faraday and is therefore active, data can be overwritten?
Yes.
So if data can be overwritten when it's not in a Faraday, you can lose that data, correct?
Is there data that we're concerned? Yes, theoretically.
Right.
Yes.
don't ask him questions. Don't try to read into it. Just answer what he asked you.
You talked about, in response to Attorney Brennan, the 12/31/56 steps, and you said the last, according to you, last movement 12/32/16. Do you recall those questions?
I recall the questions.
Yeah. To boil it down, isn't correct that that phone was moving at that time?
May I check the timestamp again?
Absolutely.
I apologize. There's
no.
a lot of timestamps going back and forth.
Please do.
12/31/56? Is that
Yeah, that's the start. Yep.
Oh, yes, this one there definitely is. Yes.
So, doesn't matter what kind of movement, but that phone was moving starting at 12:31:56 and still moving until 12:32:16 a.m. on January 29, 2022, correct?
Yes.
Thank you. Appreciate again you answering my questions.
Thank you.
All right, Ms. Hyde, you're all set.
Thank you, Your Honor.
Or I see counsel about scheduling.
So I could play it every time she says that. But I can't. Because it's a Facebook clip. Is this a long break? Did Carla get to see the clip? Oh, we don't have time to play it again.
May I?
Yes.
I would like to play clip 15, please.
Absolutely more than Jen McCabe. Jen McCabe, it's me or her. Either I'm going down, Jen, or you are.
Ooh.
Okay. All right, so folks, I talked to the lawyers briefly about scheduling at sidebar, and I'm told we're actually ahead of schedule. So with that, rather than beginning a witness who's probably going to take a while, we may as well let you go and enjoy the rest of this beautiful afternoon. So we're on schedule, ahead of schedule. We'll reevaluate that tomorrow. Now you will see the lawyers inside are asking for as well how to talk a little bit about scheduling. Those same cautions, please do not discuss this, pay independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And be very careful with your social media use. We'll see you tomorrow morning. Thank you.
All right, for the court, please. Close your notebooks to follow me.
Why don't you come on up?
Yeah, all the talking over each other was, well, it started off the talking over each other was she would like anticipate where he was going with the question and try to answer it before he was done with it, and then he was like, oh no, we can't talk at the same time. And then it became like pleasantries. It was like he would say something and, oh, absolutely, yes, thank you, and over each other through the rest of the, it was just driving me crazy. Like, there's a time and place to be that polite. This is not it. I think I would actually make a good witness because I would just sit there, yes, no. Like, I wouldn't just sit there and pour my guts out. Like, and experts never answer just yes or no. They want to spew all their knowledge. They think they know everything about everything, even the stuff they're not an expert in. I hate them too, and I don't know why they let her do it. Yeah, that seems to be exact. Like in the that guy in the Phil Spector trial, he was a forensic pathologist, and then he was telling them how a gun works. Like, you're not a gun expert. You're a forensic pathologist. That's not why you're on the stand. I mean, and they let him go on and on and on, but the judge isn't going to stop him if the lawyers don't stop him. So, yeah, I don't. In some of the documentaries that I've not seen all of them. I've seen some of them. In some of the documentaries that she did, the lawyers are sitting right there next to her. I don't understand. But I think, again, I cannot remember who said it. I think it was Peter. It said that because, like, it seems like the general public are, more of them are for Karen Read than against. So the documentaries seem like it can only help her rather than hurt her. But no, because the general public are for her, but they're not the ones in the jury that have to decide her fate. The people that are on the jury, don't know anything about the case. Hi, Mike. So they're the ones that are seeing the clips and they don't know anything about the case. So that doesn't help her when they see her all accusatory. Like that statement. It's either me or Jen. One of us is going down, or whatever she said, you know? It just makes her look like a Karen. Well, yeah, that's true. She does need to raise money. Oh, and again, if you go to Hank Britt's a fundraising page for Karen Read's legal fund, I don't know who did that, but I love it. I absolutely love it. What are they doing? I guess they're done, but I don't know why the cameras are still on. Usually they turn the cameras off and then I hear they're still doing stuff. But today we're having the opposite. Is Carla still here? Yeah, the phone experts go right over my head. But the one thing I caught was it's unknown why that search was marked as 227. That's why I was like, wait a minute. What did he just say? Because I was like, surely I did not hear that right. Did I hear that right? So her report says it's unknown, yet she gets up there and says, oh, it's because she did it on a tab that was opened at 227. That's disingenuous. I guess. I don't know, because I don't understand all this phone stuff. I don't understand coding. I used to have an app that was supposed to teach you coding, and I kept getting the little exercises wrong. I did good at first. I was doing really good at first, and then I was getting the exercises all wrong, and I was like, okay, I'm done. I'm 56 years old. Why do I need to learn coding now? It's not like I'm ever going to use it. I've always wanted to learn, though. I wish I knew about computers. What are you doing? I don't want to miss anything. I have FOMO really bad. I just want to make sure. Because knowing Bev, as soon as I shut it off, that was like that one trial. What was it? Was it Linda Sturmer? We sat here and waited and waited and waited, and I was like, okay, as soon as I turn it off, and I had just turned it off and sat down to eat dinner, and then we had a verdict. That was like, great.
I'll see you tomorrow morning. Do you have to sign my signature?
Oh, okay. I guess we're done. They didn't end or witness now. Did they say who the next witness would have been? Did anybody hear it? I didn't hear them say anything. And that's so funny that that bakery is making cookies with a picture of the fan on it. And at the bottom of the cookie, it says, if you know, you know. Man, if I got one of those things, I wouldn't even eat it. I'd preserve it somewhere, somehow. Be my souvenir. I have a souvenir from this trial. Where did my cup go? Oh, I think I already put it in the kitchen. I have a cup with a picture of a red like a coffee cup with a picture of a red Solo cup on it. It says, "Do not disturb important forensic evidence," or something like that. I don't remember what it says. Okay, guys. Well, I will see you guys in the morning again. I will try to get up early and do Phil Spector in the morning. I just wanted to sleep in this morning because I don't feel good. Hopefully, I'm going to go take another muscle relaxer. I took one, it eased off some. I didn't take two because I don't want to fall asleep on you guys. So I'm going to go take another one and maybe take a nap, and maybe I'll feel better in the morning. So it's my neck. I'm sure now. I'm sure it's my neck, because this side's really tender, and this is the side that my head hurts on. So okay, have a good evening. I will see you in the morning, my loves. Be kind to people, love your family. Jesus loves you, and so do I.